Different correction. The name of the container will be changed, my lord. Name of the container.
That is
Nikhil
appearing
Nirmal.
under the heading to be mentioned. What is the name of the container?
But earlier occasion, your lordship directed to serve the copy of the container. Due to change the name of the container, copy has not been served. And container name is Nikhil Nirmal.
It's written in here Kaushik Shah.
Yeah.
Your petition, it is written Kaushik Shah.
Name of the container change.
I cannot follow. You
For
want to change the
mention
name of the
or
container?
correction of the name.
How you will correct that? There is no mistake in the order. Now, if there is a change in the name of the container, that will be recorded accordingly in the next order. You file any application. You have corrected it and that name has been written. No order need be passed. When it is appearing?
After 4 weeks, it will be appear.
Oh, it's a service করতে পারবেন।
Your current granted leave to
This is appearing to be mentioned. For the prayer of learned advocate for the petitioner applicant, leave is granted to correct the name of the alleged container. Correct.
grateful, ma'am.
না না এটা তো এমনি আছে টু মেনশন 4 weeks পরে তো আসবেই
Grateful, ma'am.
Item 2, I am appearing for the container, my lord.
For the applicant, your lordship, like Mr. Shami.
On 2nd July, my lord, your lordship was pleased to grant some more time. And we have already made payment of rupees 2,63,000 and what? To my lord, DP Garden. Now, rest, my lord, one person, he died. No, my lord, airship certificate has been given till date. So, my lord, we have written to them to give a airship certificate so that we can disburse rupees 20 lakhs and odd to them. We have also affirmed an affidavit on 4th August, but original has been misplaced. I have a copy, my lord. Kindly see this, my lord.
সার্টিফিকেট জমা দিতে বলেছে সাকসেসফুল সার্টিফিকেট জমা দিতে বলেছে
who has not received
One of us, that will be
all others have received one means petitioner number
petitioner.
নাম্বার
My lord,
শাহজাহান
going.
এইটা 7
he has died
Yes.
so when can you produce that death certificate or the legal year certificate so that it can be
Will
disbursed?
be sharing.
Mr.
Only one indulgence, flat. This order was passed in view of the order passed by the Honorable Division Bench. That has been recorded in the order. In the Division Bench order, there was a direction for payment of interest. That was not directed here. But that liberty I have that I can file my fresh petition on that.
But the order cannot be extended to that because that is not been recorded in the earlier order.
No, that was not recorded.
Modify
That's
that.
why I cannot
I
insist,
cannot also observe anything that granted
which is not there in the original order.
Yes. Mr. So learned advocate for the alleged container submits that all the petitioners have been extended the benefit and payments have already been made excepting petitioner number 7 who has expired. Till date,
Calculation
the death certificate and legal year certificate has not been produced before the alleged contemner, for which reason the disbursement in respect of petition number 7 could not be made. Mr. Sameem Ahmed, learned advocate appearing for applicant's petitioner, submits that all the petitioners excepting petition number 7 have received their benefits. He undertakes to produce
death certificate
death certificate and the legal year certificate before the alleged contemner for disbursement of the share of the benefits in favor of petition number 7. So dispose of this writ
Yes,
petition.
my lord. Let me dispose.
No other aspect remains to be decided in the present contempt application. The same stands disposed of.
I was thinking of whether if
The moment they will give the airship certificate, we'll disburse.
Or you do one thing, after 15 days I am keeping it, you produce that death certificate, after it is released, we can dispose it
Cause of action, the written petition absolute.
as you choose.
dispose it. I think that
Dispose.
Lord, item 3, I am appearing. My lord, this is my matter, my lord. My lord can take up this matter, my lord. This is regarding, my lord, suspension of the, my lord, petitioner. Petitioner has challenged.
Release. On my personal ground, the matter is released from the list of this court.
Lordship, I beg to appear for the applicant. So will I applicant in can 1 for intervention? So will I give my
It
appearance?
is released. It will be listed.
So may I give my appearance, Your Lordship?
What appearance?
For appearance for
Give your appearance. Next.
Lordship, I am the contemner, Lordship, in this matter, Lordship. Last occasion, Lordship, matter was
What is
last occasion matter was heard before his Lordship, I adjourned for time, Lordship. Here, Lordship, as a director of pension and provident fund, wrote a letter to the Lordship Pension Sanction Authority DI.
Hmm.
To Lordship immediate to Lordship release the file, Lordship. So Lordship, as per the my Lordship information, Lordship, give me some more time, Lordship.
you that a copy of the order
आपने देखो
the instant pension case giving effect of a category. Oh. File it by way of an affidavit.
But here, Lordship,
Show him the letter.
Lordship, give me, Lordship.
You are requested to resubmit the instant pension case giving it. Show him that.
Lordship, I am giving it.
So let it come up after 2 weeks.
In the meantime,
An
Lordship,
affidavit of compliance on the returnable
Lordship,
date, because
that
there is a direction that he is requested to resubmit that, taking into account the A category scale from 1st July 2015. What is his prayer also?
yes, Lordship.
So that
But
will be-
here, Lordship, my instruction is this, Lordship, kindly give me the direction to the DI, Lordship, to the Lordship, release the Lordship file immediately, Lordship.
this is your administrative reasons.
Admitted, but Lordship, Pension Sanction Authority,
cannot.
if the Lordship, Pension Sanction Authority not released, but if the Lordship, I am only for the disbursal, Lordship. Pension Sanction Authority DI, Lordship. So, Lordship, I am only submit before his Lordship, let the, only for DI to Lordship take a decision, Lordship, immediate take a decision. I have nothing to say anything. Otherwise, Lordship, again I come before his Lordship. So, give me 2 weeks time and direction have a DI, Lordship. Only. I do nothing.
Ashok. Mr. Bhaskar Prasad Boishul, under advocate appearing for alleged contemner, submits that the senior law officer, Pension Provident Fund and Group Insurance Government of West Bengal has already taken steps and made communication with the District Inspector of Schools PE Birbhum on 31st July 2026 with a request to resubmit the pension case of the petitioner giving effect of A category scale from 1st July 2015. He files a copy of the letter under memo number 442/L/DPPG/L-3D 380/2025 dated for 31st July 2026, which is taken on record. He seeks for fortnight accommodation. Please this matter after 2 weeks per day. The alleged contemnant is directed to file an affidavit of compliance on the returnable date.
So only DI direction not necessary.
So let
After
there be
15 days,
direction
let's see
to
what is the development.
issue a fresh PPO. Also,
No,
issue
no,
a fresh.
fresh PP, I am the only for deducted amount, that amount has been returned. If the lordship
No, no,
succeed,
PPO has to be issue
Not
fresh because
necessary.
there is a direction,
Yes,
the rider
com-
of deduction of amount.
yes.
So let the
No,
fresh
PPO
PPO
is
be also.
not necessary to fresh.
There is a request to resubmit that. If that is calculated from 1st July 2015 without revision, how can this be done?
Not.
How can they revise it?
No, Lordship, in the PPO, subject to your Lordship's consideration, the PPO, there is a.
Mr. Mukherjee, if the existing PPO has a overdrawn amount indicated
Yes.
So that's,
and the DPPG writes a letter to DI stating that you resubmit that, taking into consideration A category from 1st July 2015.
Yes, yes.
So revised PPO has to be issued to revise that.
Lordship, this is my content.
that lordship is PPO lordship. If the lordship director of pension, revised pension lordship.
Next,
I'm for the
5.
petition.
The rule is that she has deposited specimen for service of rule. Demanded furnish report on the report को है. It is जाए नहीं. Copy of the order पाठाओ नहीं. Demanded had to furnish a report on the returnable date. उधर गए. No, there is no space. এটা তো 6th May এর পরে জুলাই মাসের পরে When did you deposit the special messenger cost?
On 7th May 2026.
7th May.
Yeah.
6th May তে হুম July 2026, department was directed to furnish report. It is informed by the court officers that the earlier order has not been communicated to the department. Court officer is directed to communicate the order. Department is directed to furnish report on the returnable date. Release this matter on next week. এটা আগে করিয়ে নিয়ে আজকে পাঠিয়ে দেবেন, আজকালের মধ্যে পাঠিয়ে দেবেন।
On behalf of the petitioner, my lord. My lord, today supposed to file, my lord, affidavit of compliance by the contender.
Contender appeared.
Yes, my lord, appeared.
Who appeared?
Tania Banerjee, my lord, a learned advocate.
Give her a notice. None appears on behalf of the alleged contender, not the contender is represented. By whole. None appears on behalf of the alleged contender. The applicant petitioner is represented. For ends of justice, the matter is adjourned. Any copy of the affidavit? Yes.
But I'm praying for short partial lordship. Short partial lordship. Item number 6.
Where is the affidavit of
Compliance report. I am short partial lordship.
Item number 7, my lord. I am for the contender, my lord. I am filing the affidavit of compliance, my lord, on behalf of the.
None appears on behalf of the petitioner. Alleged contender is represented. Affidavit. Okay, affidavit of compliance.
Yes, ma'am.
You have served copy?
Yes, my lord.
Affidavit of compliance.
No, my lord. At this point of time, I haven't served. I was thinking that he would have come.
Affidavit of compliance filed on behalf of the alleged contender is taken on record. Learned advocate for the alleged contender directed to serve copy of the affidavit of compliance upon learned advocate for applicant petitioner. Please this matter after 2 weeks. Give a copy to him. You are 2 weeks. After 2 weeks, this will appear.
Well,
in the meantime, you serve the copy of the affidavit.
I'll serve.
Eight.
My lord, item 8, I'm for the applicant. On the last occasion, my lord directed me to serve a copy and come back. My lord, this is the affidavit of service.
How many containers are there?
2.
2. Pradhan has been served.
Pradhan has been served. The
Bag
first,
received.
the first track report at page number 5.
Page number 5 is the alleged contempt number 2.
Yeah.
What about the Pradhan?
This is, my lord, Pradhan, for Pradhan, what I see from the track reports is, my lord, after item received at destination, the track report has not been updated. The report has not been updated.
File an updated report.
Then may I
get a
come back
further file.
serving again? I have to serve a copy again to the processor in that case.
No, only two. The other has been served, item delivered to the address.
Yes.
So two
Uh,
has been served. With regard to one, you pause of his service. Two has been served as per, what is the name?
Name is Lord's.
Falguni.
Yes. Falguni Mishra.
There was no such direction upon the engineer to do something. Was
Yes,
there?
there was. Now kindly seize the order. Page number 101. There was a direction to cause an inspection, and upon inspection, my lords, one inspection report is supposed to be furnished.
Yes.
Inspection has been completed, but no report yet has been furnished.
The inspection has been done by this engineer.
Falguni Mishra. Respondent number 2. Contemner number 2.
Affidavit of service filed on behalf of the applicant petition is taken on record. It is found that service has been effected upon alleged container number 2. The service is parable. The service is in respect of alleged container number 1 is incomplete. Applicant is directed to serve affresh upon alleged container number 1 and file affidavit of service on the returnable date. Release this matter after 3 weeks per.
Well, kindly keeps it on 2 weeks here and after I'll serve and come.
3 weeks. 2 weeks.
2 weeks.
After 2 weeks, go ahead.
Great.
এটা রেখে দিন আর একটা আছে
My lord, small indulgence, my lord, in item number 7, my lord, the petitioner is here.
I am the petitioner. I was
In item number 7, my
engaged in
lord,
court number 6.
I can serve him the affidavit in compliance, my lord, and 7.
I do not say that.
Sharp, sharp.
6 টা দিন
It was 7.
Item was
7 ওই যে এসে গেছে উনি
হ্যাঁ, মানে ওই,
কপিটা দিয়ে দিচ্ছি ওটা
লর্ডশিপ
চেঞ্জ করে দাও
অর্ডার দিয়েছিল এফিডেভিট কমপ্লায়েন্সটা সার্ভিস করার জন্য, তো পিটিশনার এসেছে।
7. Contempt.
affidavit of compliance 7 আরেকবার নিন affidavit of compliance filed on behalf of the alleged contemner is taken on record, copy served. Has it been complied with?
But then I have to just I got this.
Copy served.
My lord, inspection has been
for the applicant seek accommodation. Release this matter on next week.
Great.
আপনার ইন্সপেকশন
My lord, this is my application. It's stemming from a writ petition where my lord had passed an order. If I may take my lord through the order that was passed. It is appearing on my lord.
দেখি সার্ভিসটা কি হয়েছে
Page 66 of the application, my lord.
সার্ভিস কেস পাইতে না that is the file application.
It was for appointment of
Affidavit of service.
my lord. দাদা extra page দাদা extra page চলে গেছে। Thank you.
সুরেন্দ্র গুপ্ত Surendra Gupta. One has been served.
One has been served, my lord, much
Surendra
prior to the date.
Gupta.
Two has also been served.
Affidavit of service filed on behalf of the petitioner applicant is taken on record. It is found that service has been effected upon alleged container number 2, Mr. Surendra Gupta. Five. None appears on behalf of the alleged contemners. I record for right. Previously, service was also effected upon alleged contemner number 1, Antora Acharya. None appears on behalf of the alleged contemners. Issue rule.
Much obliged.
So other matter
will take time, Melody, I believe.
Yes.
It will take some.
Other matter.
I don't. Other matter.
কোন টাইম লাগবে?
In
There are 9 teachers of Bashirhat Aminia Senior Madrasa are before your lordship. I have served everyone. We have paid the court fees for all.
each
Court
alone.
fees, it's on record. I'm told. Kindly do not open the papers for a moment. The West Bengal Madrasa Service Commission Act, it underwent a challenge regarding the constitutionality of the act at the instance of various persons when the act came to be promulgated. In a judgment delivered by your lordship's court in 2014, the challenge was sustained. Means the act was held to be unconstitutional. Matters were carried to the Honorable Division Bench at that juncture. The Honorable Division Bench, there are orders which are a part of the records. It directed the Division Bench of this Honorable Court during the interregnum, before pronouncing the judgment. The Honorable Division Bench directed, Milord, that the vacuum created, because Milord, the schools had to function, the madrasas had to function. So, Milord, the teachers who were appointed by the managing committee at that juncture, they needed to be protected. Ultimately, Milord, certain orders were made by the Honorable Division Bench. Ultimately, in the year 2015, the latter part of 2015, the Division Bench pronounced the judgment. Again, Milord, upholding the Honorable Single Judge's order. That means, Milord, the constitutional validity of the Act sustained. The challenge to the constitutional validity. Now, Milord, these persons who are before your lordship, all these persons were appointed at a point of time when there was an absolute, Milord, nowhere situation. There were no proper guidelines apart from, Milord, a guideline of 2015, sometime in March 2015 and February 2015, and a subsequent guideline of 3rd March 2016, both of which did not contemplate elementary is prior permission. And it left on the managing committee to, Milord, create the posts to be filled up
and the posts were filled up. We were appointed at a point of time when there was no 3rd March. We were the selection process, my lord, insofar as these persons was triggered by an advertisement inviting applications from various persons in the month of January 2015. Now, my lord, since we were appointed, we wanted salary to be paid and approval to be granted. The matters from the division bench's order, the matter travelled to the Honorable Supreme Court at the instance of parties, including the state. Because, my lord, the constitutional validity of the 2009 Act, my lord, 2008 Act was sustained. The state had to carry an appeal. In those appeals, we had taken out in the year 2016, not interlocutory applications, seeking our intervention and seeking payment of salary. The Supreme Court from 2016 till 2018, particularly, my lord, insofar as we are concerned, the petitioners here, they were accorded approval provisionally, subject to the result of the appeal. Appeal means the appeal pending, the SLP pending there. It is recorded. Now, this provisional approval and payment of salary, everything was done. We are working since then, since 2016. Or even, our appointments are in pursuance of a selection process of January 2016 and ultimate appointments February, March 2016. And salary payment order is also of 2016, made by the Honorable Supreme.
Who is for the state? Madam, the question is that somebody from the department is asking to enter through video conference. When the state is represented, why the Assistant Secretary Law is here? The proceedings is before the court. The parties are being represented. Chat box is receiving that he wants to enter into the video conference. Who is this person? You find out. This Additional Secretary Law, why? If any instruction is required, let him communicate with the advocate for the state. You talk to him and tell him any instruction is required, communicate it to you. Yes.
Now, my lord, we were granted approval, albeit provisionally, subject to the result of the SLP in 2016. We were paid our salaries. We are working. All our benefits have been extended to us. Now, my lord, there were, during the matter, when the matter was being heard by the Honorable Supreme Court, my lord, a judgment ultimately came to be delivered by the Honorable Supreme Court by protecting persons who were appointed during this vacum period, so that no one is to disturb them. Taking cue from that observation, in paragraph 63 of the Honorable Supreme Court's judgment, various applications and contempt applications per se was filed before the Honorable Supreme Court, not by us, not by any of these teachers, my lord, in item numbers 10 to 15 or 10 to 14. It was at the instance of persons who were appointed but not paid their salary or not paid their approvals. The Honorable Supreme Court was hearing these matters, these contempt applications. Various directions were passed at various stages of the proceedings, ultimately culminating in an order made in 2023, whereby the Honorable Supreme Court, for those persons who were before the Supreme Court, who were yet to be paid their salaries, who were yet to be approved or accorded approval at the instance of the state, the Honorable Supreme Court, after threadbare consideration, including taking into consideration the observation made by the original division bench in paragraph 63, to the extent that no person should be disturbed, we have decided to form a committee headed by a honorable retired judge of this honorable court with two other gentlemen. The 3-member committee, whoever was before the Supreme Court and whoever was not there before the Supreme Court, meaning those persons who were yet to be approved or paid their salary, those persons, the entire bunch of cases, intermittently notices were served to the concerned teachers to produce documents, to produce papers. Concerned non-teaching staff to produce documents, to produce papers. Madrasas were also given notices. Ultimately, the 3-member committee, each case decided all against each individual teachers or non-teaching. About 450 or 300 and something, my lord. I have to check the figures. All these persons who had denied the approval, my lord, I will request any of my learned friends to correct me if I am wrong. All these persons carried matters by way of writ petitions, by way of contempt applications, because the contempt was also pending before the Honorable Supreme Court. The Honorable Supreme Court, once again, my lord, I was incidentally, my lord, assisting the Honorable Supreme Court for one bunch of persons. My lord, on a particular day, their lordships felt that you give me the best 9, whoever was appearing, and you assist me as to how they were appointed. Those persons who were before the Supreme Court and those persons who were yet to be approved or yet to be paid their salaries. The Honorable Supreme Court was not even considering the cases of persons whose approval had already been made over and who were never disturbed by anyone, even by the final judgment and order made in Muhammad Rafiq. Now, the Honorable Supreme Court, ultimately after threadbare consideration of all reports, papers, documents placed before it, made the matter CAV prior to the summer vacations of the Honorable Supreme Court this year. And my lord, on the day of reopening, 13th of July, their lordships dismissed all those matters, granting liberty to the commission, Madrasa Service Commission. Their role stems from that stage to, my lord, fill up those posts, consequent vacancies where these persons were working without salary, without any benefit. Those persons, if they are within age, to be permitted to participate in a process to be initiated by the commission. The commission's role begins from that stage. Now, my lord, taking recourse to the judgment delivered by the Honorable Supreme Court on 13th of July 2026, which had the occasion to deal with the cases of unapproved, unpaid teachers and non-teaching staff. The Honorable Supreme Court was not considering anyone else apart from those persons whose appointments were made in between 15 and 18 or 15 and 19. The Honorable Supreme Court was not considering, because post 2020 again the Madrasa Service Commission revived because the challenge by the state sustained before the Honorable Supreme Court, and my lord, the judgments delivered by your Lordship's Court singly as well as Honorable Division Bench were set aside, with a rider that persons appointed need not be disturbed in any manner. Now, persons appointed, my lord, we are not only appointed, all these persons are working with salary, with approvals granted in their favor. Now, my lord, taking cue from the 13th July judgment, my lord, the director of Madrasa Education suddenly feels it proper to suddenly put us on notice to appear before it and demonstrate our mode of appointment and manner of appointment, which has been foreclosed, by the various orders passed by the Honorable Supreme Court at various stages. My lord, this is the sum and substance of the writ petition. Page 166, I was inviting my lord to the last order, the penultimate order made, my lord, very recently, calling upon us and calling upon all these persons, my lord, to appear before the Directorate of Madrasa Education, Director of Madrasa Education, on a particular date. My lord, in that notice, your lordship will not find anyone else apart from the concerned managing committee, the concerned teachers, the head of the school, and the Madrasa board. My lord, there was no role play. But even when my lord, when the division bench of the Honorable Supreme Court in 2023 framed that committee, my lord, the Madrasa Service Commission had no role in that committee. It was never represented anywhere. My lord, though I am not saying anything today, your lordship is pleased to allow it, whatever. But my lord, this is the sum and substance. My lord, now let me show your lordship the papers. My lord, first is
First, you show your approval letter.
yes. My lord, page 154. Now, please see 28th November 2016. Now, before I show your lordship this, I request your lordship to kindly see page 147 onwards. (148). It is the same matter. Sheikh Mohammed Rafiq. Lord, salary must be paid by the state government to all the teachers, including applicants, till the end of July 2016. Then, my lord, the subsequent order made in the proceedings is of 1st of August. Interim order dated 10th May 16. Lord, interim order dated 10th May 16 is at page, my lord, 147. Shall continue till next date of hearing, subject to the condition that the teachers and employees are eligible. Then, my lord, on 16th of November 2016, at page 153, the Minorities Affairs and Madrasa Education Department is writing to the DME at page 153.
Yes.
This is with reference to the interim order issued from time to time and the comments of the bench of the Honorable Supreme Court on 9th November regarding the payment of salary to the serving employees. As content petitions have been filed and the court is insistent that the serving employees should be paid their salary, it is hereby intimated that the salary of the following staff be released immediately. My lord, these are the 9 persons. Right? These are the 9 persons, my lord, who are before your lordship in this matter.
Yes.
Then, my lord, the order of approval, I told your lordship, they were all provisional, subject to orders passed by the Honorable Supreme Court. Order of the Honorable Supreme Court, meaning the order which was, the matter which was pending before the Honorable Supreme Court at that juncture. It is these approval of appointments are accorded subject to the final decision in SLP Supreme Court in SLP civil number 6661 of 2016. Has my lord very kindly got it, the sentence. Then, my lord, my lord, please see the next document. is dated 30th November 16.
Page number.
My lord, page is 156.
Yes. Council principle.
My lord, please see. This is Learned Counsel representing the respondent number 7. The state of West Bengal submits that concerned authorities of the state have fully complied with the impugned order passed by the Honorable High Court on 9 December 15. 9 December 15 is the Honorable Division Bench's order. Honorable Division Bench's order. Together with the interim order of 10th May 2016, page 147. In order to substantiate Learned Counsel such and such, depicting a direction to release the salary of 12 and 9 contempt petitioners respectively. 9 contempt petitioners are us.
Yes.
There was a direction whether the salary was actually paid. Then, Milord, once again, there was a further direction on 17th May 2018 by the Honorable Supreme Court. Milord, personal presence, everything was done.
Yes.
Please see paragraph 2. Now, Milord, this does not necessarily affect us. Why? Because this order was at the instance of the Honorable Supreme Court in respect of teachers who were yet to be approved. Or were ongoing appointments. Milord, our appointments are earlier, 16. And we were before the Supreme Court in 2016 itself. Now, Milord, be that as it may, it's my duty, Milord, to point out paragraph 3. At the same time, it was pointed out by Mr. Khurshid, Milord, and other learned counsel appearing on behalf of who are working in various, that they have not been paid their salaries in spite of orders passed by this court from time to time for disbursement. It was pointed out by Mr. Parasaran that certain incumbents are not found to be eligible, as such their salaries have not been disbursed. It appears that pursuant to the order of the division bench, the state government has come with a notification dated 3rd March 16 prescribing the eligibility conditions for appointment and containing educational qualifications for the teachers to be appointed. In view, we order that in cases of incumbents who are working are possessing qualification as prescribed by the state government in its aforesaid notification, the payment shall be made to them and they shall not be deprived of their dues. Let this order be complied with in respect of with respect to the payment of salaries, also within a period of 2 months, such as assured in all fairness by Mr. Parasaran appearing for the state. Even if the teachers have not been paid for the period prior to 3/3/2016, that is the notification date, they shall be paid their dues for the period they have served. It is made clear all incumbents shall be paid their dues in terms of this order, whether they have approached this court or not, and this order to be applied to all similarly circumstanced individuals. As there are large number of vacancies existing in the various, we permit declaration of the result of the recruitment process of 2014. However, no further recruitment process shall be undertaken. It is also stated by the state government and the commission that only those madrasas who want to take the incumbents from the list of 14 process, the commission shall sponsor their names, etc. The process shall be done strictly and in accordance with the merit list and candidates, and the appointment show made shall be subject to the final outcome of the case. And then paragraph 7, no equity shall be claimed on the basis of appointment on stopgap arrangement, etc. This is at a stage of 2018. Our stage ends in 2016. Provisional appointments made, subject to further orders made by the Honorable Supreme Court. Now, please see the final order made by the Honorable Supreme Court, which your Lordship will be pleased to find at page, it begins from page 163. I was slightly incorrect. I had told your Lordship paragraph 63. It is actually paragraph 58. This is what the Honorable Supreme Court said in paragraph 58 of Muhammad Sheikh Muhammad. The entire judgment is with me. It is a reported judgment. It is reported in 2020, volume 6, SCC 689. My lord, this is the judgment. My lord, please see. My lord, this is what was quoted in paragraph page 165. Page 165 of the writ petition. My lord, the entirety of the judgment I have handed over, paragraph 64 of the SCC. In the end, my lord, that also finds place in page 165. In the end, we declare all nominations made by the Commission in pursuance of the provisions of the Commission Act to be valid and operative. However, if after the disposal of the matters by the High Court, any appointments are made by the madrasas concerned, such appointments of teachers shall be deemed to be valid for all purposes. But the Commission shall hereafter be competent to select and hereafter post. Then, my lord, we have annexed pages 166 and 167.
But your case is prior to disposal by High Court.
Yes. My lord, our case is after disposal of the High Court, before the Supreme Court was entered into by the state.
No. When was this approval made on?
My lord, our approval is 2016. Page 1.
28th November 2016.
Yes.
And the disposal by the High Court?
9th December 2015. Division bench. And single bench is of 2014. 12th March 2014. 12th March 2014.
Yes.
Now, my lord, please see. After this disposal by the Honorable Supreme Court by its judgment, which I have handed over, my lord, matters travel to the Supreme Court at various stages. First stage is, my lord, contempt applications were filed, alleging that the Supreme Court directed payment of salary, why will we not be paid, why will we not be approved, etc. The Supreme Court, my lord, in order to set the clock straight and, my lord, put the entire controversy to rest, delivered a judgment, my lord, which is reported in 23 volume 18 SCC, page 529. Snehashish Giri versus Subhashish Vitro. 23 volume 18 SCC 529.
Yes, which is the relevant paragraph.
Well, before I show you, Lordship, what was the subject matter, I'll just explain, my lord. Please see paragraph 2. This order, my lord, very kindly got it.
Yes.
My lord, this order, as my lord got paragraph 2, will dispose of several contempt petitions with complaint of willful and deliberate violation of judgment of this court in Muhammad Rafiq versus Contai. This court had to consider the correctness of the view. Paragraph 2. Expressed by the Calcutta, which held that some of the provisions of this was unconstitutional. Those provisions regulated the process of appointments of teachers in aided madrasas, which were recognized as minority institutions. This court recorded its finding that the provision in question, that is section such and such, were valid and constitutional. At the same time, the court was conscious that some appointments were made by the madrasas during the pendency of the appeals and held as follows. Paragraph 64 was quoted.
Yes.
All the petitioners argued. Who are the petitioners who were arguing? That even during the pendency of the proceedings in appeal, content proceedings had been drawn seeking release of salaries of teachers who were appointed after the provisions were declared unconstitutional. We are not those teachers, my lord, or non-teaching. We are those persons whose salaries had been released. The state examined. Only, my lord, our approval was provisional, subject to further orders made by the Honorable Supreme Court in SLP 6661 of 2016. We are not anyone else. So the persons before the Honorable Supreme Court in this matter are the persons who were yet to be benefited by approval orders or salary. Ultimately, my lord, without taking your lordship's precious time, this is what the Honorable Supreme Court held. Paragraph 17 at page 540. Just one second. Now, my lord, please see, during the hearing, paragraph 17, the court had suggested the constitution of a committee which would go into all relevant factors and verify the claims of the petitioners. Who are the petitioners? Unapproved, unpaid. Then the Honorable Supreme Court took suggestions from everyone.
Yes.
And, my lord, accordingly, this court, in exercise of powers under Article 142, hereby constitutes a committee headed by Honorable Judge. The committee also shall consist of a principal secretary, etc., etc. The state government shall nominate the members of the commission. Whether the madrasa or its managing committee was recognized by the state, the date. These were the parameters to be gone into. F, 6 parameters. Now, these 6 parameters were gone into by this committee. And ultimately, this committee did not accord approval even in favor of one teacher. For whatever reasons, I am not going into it. The matter has been carried to the Supreme Court. The Supreme Court has been disinclined to interfere. This committee that was formed now, ultimately, this committee's decisions, all other ancillary matters, including non-grant of approval, was freshly put to challenge in a judgment, in a writ petition registered as WP Civil number 566 of 2024. I think Mr. Dhor, my learned senior friend, has handed over a copy. I am grateful to him, though I am not grateful regarding his presence. We are very close, otherwise outside. Kindly ignores this banter.
Yes.
Please see, it is reported in 2026 SCC online. 2026 SCC online, SC1C1C. এই জন্য বিয়ে করতে হয়, বিয়ে করলে তুই এক কথাতে শুনে নিতিস। 2026 SCC online SC1C1C.
Yes.
Lordship has got the copy.
Please see paragraph 2. I had the occasion to assist the court. I know what was passing through the court's mind. Their lordships were absolutely not pleased with the entire scheme of things for whatever reasons. This batch of 49 petitions under Article 32 of the Constitution at the instance of petitioners numbering in excess of 350 are proposed to be decided by this common judgment and ordered in the light of the commonality of the facts involved and the questions of law arising for decision.
Yes.
insofar as the identity of the petitioners are concerned, they claim to be teachers and non-teaching staff of various madrasas in the state. The singular grievance expressed by these petitioners related to alleged deprivation of their legitimate service benefits. Pausing here, the grievance was deprivation of legitimate benefits, which ought to have percolated post Muhammad Rafiq's paragraph 64. According to these persons, multiple judicial proceedings preceded these writ petitions. The original cause of dispute related to the virus of certain provisions of this act, while the challenge to the enactment attained finality by this court's judgment in such and such. That is the Muhammad Rafiq's judgment, which I have handed. The present dispute stems from subsequent proceedings instituted to enforce this court's order. Pausing here. Subject to correction by my learned senior friends, appearing for the petitioners in the other matters. We were all throughout paid our salaries. We were all throughout accorded approvals. So we were not before the Supreme Court. And the Honorable Supreme Court never ever had the occasion to disturb the existing arrangement insofar as persons who were already approved. Because, assuming but not conceding their approvals were provisional, but that provisional approval, as would appear from my document, was subject to Sheikh Rafiq. And this order is not an appeal from Sheikh Rafiq. This order is an incidental order of independent writ petition. The undisputed facts are, their lordships has been pleased to quote. Regulation of madrasa education in the state of West Bengal by enactment is not of too distant an origin. The West Bengal such and such act was enacted to establish a madrasa board in West Bengal and to provide matters connected therewith and incidental thereto. In terms of section 38 2C of the 94 Act, the state government, after previous publication in the Gazette, framed the management rules of 2002. The management rules contained provisions of constitution of the managing committee of the madrasas, their powers and functions, including the power to appoint staff, both teaching and non-teaching. Prior to the enactment of the Madrasa Service Commission Act, the managing committees of the madrasas, recognized by the madrasa board and the council receiving financial assistance, were required to appoint teachers on vacant sanctioned posts on the basis of recommendations made by the relevant regional service commissions. Although section 15 of the expressly excluded educational institutions established and administered by religious and linguistic minority from its coverage, provisions of the SSC Act still applied to such madrasas which were yet to be formally recognized by the state government as having been established and administered by a religious minority. These were the ancillary discussions. Please come to, then I request your lordship, to kindly come to internal page 5. The page numbers at the top 5. Prior to paragraph G.
Yes.
Prior to and post the said judgment and order of the division bench, the state government had issued 2 notifications, 9 February 15 and 4th March 16. While notification laid down recruitment procedure in the institutions exempted from recruitment from West Bengal School Service Commission under section 15A, notification 2 introduced recruitment procedures for the non-government aided madrasas 2016. Will not interrupt, just pausing here for a moment. Our appointments are prior to 3rd March 16. And the state government, your lordship has been pleased to see, even in 2018 made submissions before the Honorable Supreme Court that certain teachers are not eligible, so therefore we are not inclined to extend any salary benefits to them. Whoever is entitled, we have given them. They have granted us approval, meaning thereby that they were or they are satisfied regarding our eligibility, the qualification part. It is not anyone's case for the moment that a class 8 pass out is teaching in the class 12, or a particular subject is being taught in which he is not an expert or not, he doesn't have any expertise in the field. Be that as it may, then is paragraph, then please come to not straightway, not at internal page 7. Internal page 7, paragraph N.
Yes.
Closure of the appellate proceedings triggered by the challenge to the MSC Act did not bring about a quietus to the controversy. Rather, it was quickly followed by initiation of petitions alleging contempt of the directions of Sheikh Muhammad Rafiq. The contempt petitions came to be decided by a two-judge bench presided over by Honorable Justice Bhatt, as his lordship then was, by the judgment, my lord, that is Snehashish Giri 2318,
Yes.
regarding the committee and its constitution thereof. Then is paragraph O. My lord, paragraph O is at page 8, bottom. Disposal of the contempt petition on the above terms resulted in a deluge of applications being filed before this court to have the same reversed. First, an application seeking modification of Snehashish Giri was filed by a group of candidates. On 22nd August, the said application was dismissed as withdrawn with liberty. Next, a petition seeking review of order of Snehashish Giri was filed. But none of these proceedings were at the instance of persons who were already approved. Milord, just to put it this way, on the promulgation of the SSC Act, post promulgation of the SSC Act, recruitment was routed through the SSC. Anyone who was appointed in 1996 by the managing committee is still serving, maybe Milord, he is on the verge of retirement. His services were not disturbed by any proceeding. Whatever approval, whatever has culminated into orders of payment and orders of salary were never touched in any of these proceedings. Milord, then, Milord, I request your lordship to come to paragraph P. Meanwhile, the state government had proceeded in the matter directed by this court. Directed by this court meaning, Milord, 2318 direction. By nominating the members of the committee other than the chairman, notifications were issued inviting claims. The committee, having examined the individual claims of a little less than 500 claimants, teacher and non-teaching, prepared a report with its observation in respect of each and every claimant. Not a single teacher or non-teaching staff could substantiate his or her claim before the committee of being validly appointed, resulting in rejection of such claims. So those persons, around 350 in number in various proceedings in these 49 writ petitions, were before the Honorable Supreme Court. Now, Milord, then is paragraph S. Finally, all the writ petitions upon consolidation were placed before us and preliminary hearings conducted. What was observed in course thereof is captured in our order dated 19th November 15. Milord, noticing the deficiency, we had requested, Milord, I told your lordship, Milord, I told your lordship that because the Supreme Court insisted that 10 cases to be given to it, or 9 cases to be given to it, best cases. So this is that order which the Honorable Supreme Court is referring to. On an earlier occasion, noticing the deficiency in the pleadings, we had requested the advocates on record for the petitioners to project before us 10 most glaring cases where the petitioners, despite creditworthiness of their claims, might have been meted out injustice by the committee. No such exercise appears to have been undertaken. That is what their finding, their lordship's finding is. We once again granted liberty to the advocates to identify cases of more than 10 teachers. And, Milord, there were again various directions. Apart from the directions in 2318 SCC, these were the other directions, Milord. These 10 directions. Yes. As quoted in paragraph, as quoted in page 10.
Yes.
Ultimately, Milord, these were the cases that were considered. 7, paragraph 7. Now, my lord, ultimately is paragraph 12, 13.
Yes.
My lord, I request your lordship, my lord, I'm not going to trouble your lordship to the entire thing, because this one fact is very clear, that these persons are not these persons here. These persons are persons who are yet to be approved and still not approved, still not working. Well, ultimately, my lord, paragraph 41 may kindly be looked into. Well, just 1 second, my lord, it's my, I'm grateful to my learned friend. Paragraph 17 may kindly be looked into. Paragraph 17.
Yes.
It is therefore clear, I'm sorry, my lord, has my lord very kindly got it? It is therefore clear as day that observation made in paragraph 64 of Muhammad Rafiq was duly considered in Snehashish Giri, and bearing in mind the factors referred to in the extracted passages, further directions were issued regarding constitution of the committee for verification of the claims. On the point as to whether the appointments are valid or not, the directions in Snehashish Giri constitute the binding directions which each party to the list is now bound to follow. Each party to the list, not, my lord, it cannot be, this order cannot be construed, in my most respectful submission, to allow a floodgate to be opened to explore, my lord, the appointment of a teacher who was appointed, my lord, maybe prior to the promulgation of the 2008 Act. It does not, my lord, envisage that situation. The list and the parties to the list, meaning the parties who are before the Honorable Supreme Court.
Yes.
Then, my lord, paragraph, I was tempted to cite, my lord, so as to avoid, my lord, time constraint, because other lawyers or counsels are there, my lord. Paragraph 18 may kindly be looked into. Here, appointments were made after the Honorable Supreme Court was pleased to stay the operation of the judgment of the Honorable Division Bench. Our appointments were at a prior point of time. We have annexed documents, my lord, here, evincing facts, my lord, how as to, my lord, our appointments, in which subjects we are working. We have indicated everything, my lord, the staff pattern, everything, for your lordship's gracious consideration. Ultimately, my lord, the direction of this court in this matter flows from paragraph 41.
Yes.
Paragraph 41 onwards, and ultimately, my lord, since I told your lordship at the outset that these have now been routed through the commission, that that direction your lordship will be pleased to find at paragraph 44.
Yes.
Now, my lord, this is the sum and substance, my lord. Keeping this in mind, this order, which, my lord, is the impugned order in the present proceeding, (166) may kindly be looked into. My first and foremost submission is in compliance with the verdict. The verdict never envisaged this. The verdict in Najma never envisaged this situation. There was no conflict. The verdict is clear as water. The writ petitions were dismissed. Appointments have been directed to be routed through the commission henceforth. So, in compliance with the verdict never said that you reopen cases to find out. That was never the verdict. In fact, the verdict was considering persons who were before the Supreme Court parties to the list. So, in such view of the matter, my lord, my humble submission appearing for the petitioners, my lord, my learned friends will also address your lordship, appearing for the petitioners.
Yes.
This office requires to verify the validity and legal. Where is the power? I put this question to myself, my lord. The office is the office of the Directorate of Madrasa Education. Where is the power to reopen cases? Has anyone told them to reopen cases? Is there any direction? My lord, on this, my lord, the questions of law that I want to say, the memo, this document, this document does not have any statutory backing. It is just the creation of a particular officer who suddenly gets triggered by the dismissal of Najma and other bunch of petitions. I could have understood that any one of us are similarly like them. No. With greatest of respect to your lordship, no. Second submission is, my lord, all these persons who are working since 2016 with salary, with approvals, provisional is subject to SLP. Provisional is not subject to Najma. Najma was never there. Snehashish Giri was not there. So, my lord, in the conspectus of those facts, all these persons today are working for a period of more than 10 years. In fact, all of us, all these teachers who are before your lordship, they have altered their position in life. It's a completely different situation, changed circumstances. And post-traffic, their services were never disturbed or touched. They have 6 years have lapsed without post-traffic.
Yes.
Then, my lord, other legal point is the authorities cannot review a decision which was taken by them in 16 suddenly without there being any change circumstance. Najma is not a change circumstance. Najma is not at the instance of persons who were approved, whose approvals were questioned. It was at the instance of contempt petitioners who were in Snehashish Giri, subject to correction by any of my learned friends. Now, my lord, last but not the least, my lord, I, appearing for the petitioners, respectfully may not pray for staying the operation of this attempt by the madrasa, the Directorate of Madrasa or whoever, my lord. I am seeking your lordship's high prerogative mercy, my lord, to kindly extend your lordship's benevolent hand, my lord, in favor of these persons. They have not committed any fault. They were before the Supreme Court. They disclosed all their cards. Their approvals were made. apropos Supreme Court's intervention, today a directorate of madrasa or director of madrasa can reopen, may not settle issues. And there, may not, they are stopped from doing so. We have also taken that legal point, those are there. Our eligibility and qualification, is at page 60, 52 onwards. I'm sorry, 62. 62 onwards is the staff pattern. Advertisement, everything is there. We have disclosed all our documents. Advertisement is at page 64. That is published in Statesman, 23rd January 16. And 63 and 64. 64. In 2 newspapers. We were called for interviews. We were called for admit cards were issued in our favor. Yes. And on 23rd February 16, the secretary of the managing committee informed the DME as well as the DI about the recruitment process. That is at page 65.
Yes.
So, this being the position, I won't trouble your lordship with anything beyond this. Your lordship will kindly permit us to pray for an appropriate interim protection at this stage.
Okay.
So those are my submissions appearing for the petitioners in the first matter. Second matter, those are my submissions insofar as. Mr. Mujumdar is here. If any assistance is required, I'll come. I'm slightly professional. Grateful to your lordship.
Yes, thank you.
And if your lordship kindly takes item 14 of today's list.
Item number. In 11, 12, 13, who is appearing? In 11, 12, and 13?
All identical.
All identical.
I think Mr. Sanyal is appearing in item 12.
Okay. Any additional point you?
Additional point, just additional. Nothing more. Lordship will kindly take my petition. I'll be very quick, my lord. Kindly take my petition. First, my lord, kindly take from page 64.
This is also Bosirat?
No, this is Kontai Rahmania.
Kontai.
The school is Kontai Rahman. It has 14.
64. Yes.
Yes. Lordship will find at page 64 the appointment of letter of issued in favor of petitioner number 1, dated, my lord, 14 December 2015. Then, my lord, for Muhammad Ahsan Ali, petitioner number 2, it is at page 66. Moidul Khan, my lord, date of appointment is 3rd December 2015 at page 68. Page 70, your lordship will find the appointment letter issued in favor of Sheikh Aspiauddin on 3rd December 2015. At page 72, your lordship will find the appointment letter issued in favor of Rijia Khatun. At page 74, your lordship will find the appointment letter issued in favor of Anwar Ali Khan. Your lordship will find most of the appointments. Taha Ali Khan, your lordship will find at page 76, and Aspak Ali Khan at page 78. Well, apart from, my lord, Muhammad Ahsan Ali, all were appointed in the month of December 2015, and Ahsan Ali was appointed in the month of January 2016. Kindly take the approval letters. It starts at page 80. This is the first set of approval letter. Your lordship will find against each candidate, my lord, the date of approval, the effective date of approval is also indicated. That is the date of appointment. My lord has got that? Date of approval from. So, my lord, it relates back to December 2015. My lord has got that?
Yes.
And my lord, this was provisional approval granted subject to the result of the final decision of the Honorable Supreme Court in Mohammad Rafiq, that is Contai Rahmania's full case. Now the other set, my lord, finally at page 84, your lordship will find this provisional approval was extended until further order for these 4 petitioners before your lordship.
There are 4 petitioners here.
No, the other set is from page 85. There are
They
7 petitioners.
Non-teaching staff.
Yes, seven, my lord, petitioners. Lordship will find, my lord, the qualification also given, and my lord, the date of approval relates back to the date of appointment. My lord has got that?
But then 85 and 86, in all there are only 5.
My lord, there are, my lord, at 87, 86, my lord, your lordship will find the last approval, provisional approval letter, which is which was issued until further order, subject to the result of the judgment to be rendered by Honorable Supreme Court. So it's all there. I mean, let's quickly, I take your lordship to some of the interim orders passed by the Honorable Supreme Court. Page 98. First page 96, my lord, kindly take page 96. This will do. Lordship will find this dated May 10, 2016, where the Honorable Supreme Court was pleased to direct that salary must be paid by the state government to all the teachers or employees, including the impleading applicants, till the end of July 2016. My lord has got that? This interim order was extended till the disposal of the matter, as would be evident from page 104.
Yes.
My lord has got that? 104, 105. But the final judgment was rendered by the Honorable Supreme Court on January 6, 2020. In the meantime, my lord, several contempt petitions was filed. A compliance evidence was filed by the state of West Bengal. That is at page 110. This is extremely relevant. Your lordship will find kindly take page 117, which is part of the compliance affidavit. Because at that stage, my lord, they were not even complying. The state authorities were not even complying with the direction of the Honorable Supreme Court regarding payment of salary. 117, your lordship will find the list of employees. Serial number 124 at 117. They are petitioners before your lordship. Similarly, kindly take page 122. This is another list for non-teaching staff. Serial number 9 to 11 are now petitioners before your lordship.
What about the other?
That is, my lord, 124 at page 112. Serial number 124 at page 112. I'm sorry, my lord, I should have pointed it out.
No, there are 8 petitioners.
There are 7 petitioners. 7 petitioners.
7?
7. Not 8 petitioners. I'm sorry.
8.
I'm sorry, another 16. Serial number 16. 123. I'm sorry.
Oh.
So there are 8 petitioners who were getting salary. Well, finally, your lord, my learned friend Mr. Bhattacharya already placed the operative part of the judgment rendered by Supreme Court in Contai Rahmania. That is our own school. Then, my lord, kindly take the judgment. Well, I will only show just couple of paragraphs from my lord Najma Khatun. In fact, Najma protects the right of the petitioners before your lordship. Najma, your lordship has got a copy, I believe.
Yes.
Your lordship has a copy.
ওটা দিয়ে দিন, এটা আছে।
Straight away, kindly come to Najma. Your lordship will find kindly take when the entire history has been narrated regarding this litigation has been narrated at paragraph 5 of Najma. Lordship will find the entire history. And it refers to two notifications issued by Honorable Supreme by the state of West Bengal. The notifications being dated 9th February 2015 and 4th March 2016. So, my lord, your lordship will find the first notification was issued, my lord, prior to the decision rendered by the division bench of Honorable High Court, this Honorable High Court. The second notification was issued
Is the date
subsequent
of
to
that order? Division
the,
bench?
yes, August 25, 2015. Sorry, December 9, 2015.
9 December 2015.
Yes, that is prior to this is the date of delivery of judgment by the Honorable Division Bench. At page 87, my lord, your lordship will find that judgment. And this notification was issued on February 9, 2015. My lord has got that order?
Yes.
Then, my lord, the second notification was issued on March 4, 2016. That is during the pendency of my lord special petition before the Honorable Supreme Court. On March 14, my lord, kindly take note, subject to your lordship's kind consideration. On March 14, 2016, my lord, the Honorable Supreme Court was pleased to stay the operation of the judgment and order rendered by division bench, and thereby, my lord, state the operation regarding, my lord, the validity or otherwise of the Madrasa Service Commission Act. Your lordship will find that order at page 92 of my petition. There shall be stay of impugnation. At 93, your lordship will find the stay, the operative part of the order dated 14th March.
Yes.
Now, my lord, now kindly come straight away to Najma. How Najma protects us, my lord, your lordship will kindly take, my lord, page, what should I say, my lord, part of, your lordship is looking at SCC online, I suppose. Yes. Then, my lord, kindly take, there is a pagination at the top, your lordship has got. Kindly take page 5.
Yes.
Well, it refers to the notifications. Then, kindly take page 6, J and K, subparagraph J and K. This is regarding, my lord, the orders. No. 5-10 minutes. Orders directing payment of salary. Then, my lord, kindly take paragraph, subparagraph N. Snehashish Giri has been referred to. That is, my lord, 2018. Then, my lord, kindly take subparagraph S at page 9. My lord, my learned friend, my lord, Mr. Dhar, appearing for Madrasa Service Commission. It has been, as my lord, pointed out by Mr. Dhar, that, my lord, Madrasa Service Commission was impleaded as a party respondent in the proceedings. I believe, subject to correction by Mr. Dhar, at no stage of proceedings, my lord, Madrasa Service Commission was, my lord, filed any counter to the writ petition so filed, which were decided in Najma. So, my lord, now kindly take this paragraph S, where, my lord, the Honorable Supreme Court, at an interlocutory stage of the proceedings in Najma, formulated the questions to be answered by the respective petitioners. And my lord, the questions were limited to the petitioners. The lordship will find 10 questions were formulated at paragraph page 10 and page 11.
Yes.
So the questions were limited to petitioner. This is in addition to the recording of the fact that the proceedings are limited to the parties to the list at recorded in paragraph 17 of the judgment in Ranjima. Then my lord, kindly take the next relevant paragraph would be paragraph 20 and 21. 20 refers to the notification dated 9th February 2015. 21 refers to, my lord, the notification dated 4th March 2016. Notification 1 is 9th February 2015. Notification 2 is March 4, 2016.
Yes.
Paragraph 20 and 21.
Yes.
Then I need not waste your lordship's time any further. Kindly come to paragraph 41. May I read out paragraph 41? Kindly bear with me. For paragraph 41 and 42, it is absolutely necessary that I read it out in its entirety. In view of the order dated 14th March 2016 granting stay, the judgment and order of the division bench under appeal, in which the judgment and order dated 12 March 2014 of the single judge had merged, did not get wiped out from existence. However, definitely the same was the operative judgment and order until 14th March 2016. And as soon as the stay was granted, it became inoperative. The order of stay, read with the subsequent order dated 17th May 2018, referred to above, thus created a vacuum. Neither MSC Act nor Notification 1 or Notification 2 could operate, which were issued in the aftermath of the two judicial decisions, single bench and division bench of the High Court. To overcome the stalemate regarding the filling up of vacancies, the managing committees of the madrasas seeking to fill up vacant posts ought to have approached this court to guide them as to which law should they follow. They could not have on their own proceeded with the appointment process, perceiving notification 1 or 2 to be still valid and operative qua the madrasas. As a stream cannot rise above its source, notification 1 and notification 2, owing to its existence to the judgments of the single judge and the division bench of the High Court dated 12 March 2014 and 9 December 2015 respectively, could not remain operational once latter judgment was stayed. Indeed, the appointments came to be made in a couple of cases post reservation of judgment in civil appeal number so and so. That is the Rahmani, that is the Muhammad Rafiq. The undue haste in making appointments without waiting for pronouncement of the reserved judgment and of the antedating of documents to evade the consequences thereof speak for itself, finding merit in Mr. Ahmedi's argument. And apart from what we have held above as to the unsustainability of the petitioner's claim, we also hold that any appointment made in madrasa after 14th March 2016 without obtaining express permission of this court is also expressly illegal and cannot be sustained. So, my lord, the judgment is limited to the petitioners and to the appointments made after 14th of March 2016. Any appointment made prior to 14th of March 2016, for which, my lord, directions were given by the Honorable Supreme Court for payment of salary to such employees, my lord, those appointments cannot be touched on the ground that in their own perception, that's the perception of the department, that they are now complying with the directions contained in the judgment rendered by the Honorable Supreme Court in Najma. So, my lord, the directions contained in Najma never say that you can't now come and re-examine the appointments which were given prior to 14th March 2016. Well, I have demonstrated from my papers that all the petitioners were appointed prior to 14th March 2016. There is no doubt about it. Their appointments were approved also with effect from a date prior to 14th March 2016. That provisional approval orders were extended from time to time, and until further order to be passed in Contai Rahmania, which your lordship will find in page 80 and 85. Then, my lord, may I just indicate '80, '85, '86, my lord, kindly 80, '85, '86. Your lordship will get all the details from there. And in all those appointment letters, your lordship will find all the approval orders. Your lordship will find the date of appointment or the effective date of approval has been indicated, which is prior to March 14, 2016. Similar now kindly come to the impugned memo, which is at page 304 of the writ petition. Identical memos have been issued with respect to all the petitioners before your lordship. So, my lord, I need not take the memo. Kindly take the memo. My lord, the author of this memo. The author of this memo is direct. I'm sorry, 304. I'm so sorry, my lord, 304. I'm extremely sorry, my lord.
304.
I should have indicated the page.
Yes.
My lord has got one of those memos. There are several memos, in fact. One memo, so far as Contai Rahmani is concerned, your lordship will kindly take. It is the director of Madrasa Education, West Bengal, who is now attempting to undertake an exercise of re-examining the appointments made prior to 14 March 2016. There is no doubt about it.
Yes.
The memo does not expressly say that these appointments would be, in fact, by this memo, not only the director of Madrasa Education is misinterpreting or misconstruing the judgment or directions contained in the judgment of Najma, but they are also acting in supersession of the decision of the committee constituted by the court. My lord, a cutoff date is fixed. Before the cutoff date, everything valid. The Supreme Court holds that. Subsequent to the cutoff date, nothing is valid. Everything goes. Admittedly, my lord, the documents would demonstrate that this is all the actions relating to my appointment, all the steps taken relating to my appointment, including appointment, were prior to 14 March 2016. So, my lord, my respectful submission before your lordship is that we all know that Article 144 of the Constitution requires all the civil authorities to act in aid of the Supreme Court. And I don't remember the exact language, something like that. A Constitution. Now, my lord, taking aid of a judgment rendered by the Honorable Supreme Court, kindly take Article 144. Yes. Yes, the language is like that.
Yes.
All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. The authority here, not only it is not acting contrary to the directions of Supreme Court, but my lord, it is misinterpreting the decisions rendered by the Supreme Court. It is also, my lord, interfering with the directions contained in Rahmani at paragraph 58. My lord, that is the original judgment. So in my most respectful submission before your lordship, and my lord, I will stand corrected again by Mr. Dhar, when Najma was heard, or even Snehashish Giri was heard, my lord, the Madrasa Service Commission did not make any submission at all. Secondly, the committee which was constituted by the Honorable Supreme Court did not have any member of Madrasa Service Commission. There was an honorable judge of this honorable court, Justice Devi Prasad De, one IAS, and one, my lord, the secretary of the education department or something like that. So, my lord, even the Supreme Court consciously never included a member of MSC, that is Madrasa Service Commission, in the committee to consider the validity of the appointments. In view of these submissions which I am making, my lord, I am praying for immediate stay of the operation of the proceedings initiated with the issuance of notice at page 304. These are my respectful submissions. Well, I will come back, my lord, if your lordship needs my assistance.
Nothing left to be pointed out before your lordships, except two things I point out to your lordships. Kindly, my lord, I place before your lordships my approval letters at page 66. 12. It's the petition number 19910.
You are for 3 items, 11, 12, and 13.
Same notice, my lord. Almost this will cover the other two.
No, 11. You are moving 11.
11. No, this is 12, 11. 12. 19910. তাই তো?
কি করেছে গো? Item number 4. Oh, 12.
Your losses will find page 66. Kindly take a minute.
How many petitioners are there?
2.
Yes.
My lord, page 66, this is approval order dated 15th November 2016. My lord, I take your losses the provisional approval appointment of the following teaching staff. 3. My lord, reference number 3. In compliance with the interim order issued from time to time and the comments of the bench of the Honorable Supreme Court in connection with SLP number such and such, Mohammad Rafiq and Managing Committee Kontai Rahmania High Mother with contempt petition number such and such. In reference to the above, the undersigned has to state that the provisional approval of the appointments of the following teaching staff of his school are hereby accorded on salary as admissible under the rules with effect from the date noted against that. But kindly take, my lord, the names have been referred to Mutar Hossain and Syed Ahya Ali, and the qualifications they are mentioned and date of approval. Then your lordship say, my lord, this order is issued without prejudice to the rights and contentions of the state government. These approval of appointments will abide by the result of the aforesaid SLP and connected applications pending before the Honorable Supreme Court. Now, my lord, of course, before lordship has already been placed, my lord, the page 280, my lord, of your lordship's brief, the judgment of the Honorable Supreme Court start at page 113. My lord, the relevant page would be, my lord, the page 283. It's the continuation of paragraph 58.
Yes.
However, if after the disposal of the matters by the High Court, any appointments are made by the concerned madrasas, such appointment of teachers shall be deemed to be valid for all purposes. So, my lord, kindly consider our approval letter also, date of approval 15th November 2016. Appointments, my lord, I have annexed 27 January 2016 at page 62. And the judgment of the Honorable Division Bench dismissing the appeal on your lawsuits 19th December 2015. That's at page 67. Now, my lord, therefore, this is not open to them to question our appointment and the parallel proceedings. What your losses can say 283, but the commission shall hereafter be competent to select. That's their post-judgment right. Now, as I place with your losses, they have once examined when the approval was given before the Supreme Court, Mala, that says my approval letter. They mentioned my qualifications. Kindly see. And now I take your lawsuits to the compliance affidavit. That's at page your lawsuits will find. Starts at page 93. Kindly see. It is also clarified. Page 93 starts the compliance affidavit. And this was filed by the Contemner Principal Secretary, Minority Affairs and Madrasa Education Department. Page 94.
Yes.
Now, kindly see, at the outset, it is relevant to state that the state government has passed orders dated such and such, releasing payment of salaries to all 16 contempt petitioners and contempt applications such and such, as well as the government order releasing salary of the such. Now, I am on paragraph 3. Pursuant to the Honorable Court's order dated 10th May 2016, the state government white order dated 22nd July 2016, upon examining claims. So claims, my lord, examine before filing the the compliance report. And kindly see our names in this compliance report. Your lawsuits will find at page 101, continuation of this affidavit. Page, my lord, 1 and 2. My lord, serial number 1 and 2. One more thing I point out to your lawsuits. Kindly see page 90. Kindly take up page 94 once. Page 94, the affidavit of compliance before the Honorable Supreme Court.
94.
94. Kindly see, my lord, paragraph 5. It is also pointed out that eligibility criteria applicable to the teachers is pursuant to the government order dated 9th February 2015 issued for schools. But what I'm pointing out, therefore, while filing this affidavit of compliance, they have considered examine our cases in terms of this, whatever right, correct, all that. This, now kindly take up your lawsuit, the impugned order. Impugned order at page 284. Well, phase-wise, they have granted the payment of salary.
Page 80.
284, the impugned order before your lawsuits.
Yes.
Kindly see, Malan. In compliance with the verdict dated 13th July to passed by the Honorable Supreme Court. Malan, we are not covered by Najam Khutta. We are not before the Honorable Supreme Court. Our cases are governed, Malan, when the main SLP was pending from the judgment of the our division bench. That's why, my lord, your losses will find in the compliance affidavit SLP number 6661. Losses, once take it up. 93 page for your lordships. Page 93, affidavit compliance. In connection with contempt arising out of the judgment passed in this matter. And now you are referring to a judgment governing the others. This is first, my lord. And now kindly see, my lord, the content of it. This statement in some or not, the office requires, after skipping over the first 4 lines, the office requires to verify the validity and legality of the recruitment process, followed by issuance of appointments by the concerned manager in the light of the aforesaid judgment. Well, that judgment doesn't apply to us first. Then, your lordships, the guidelines laid down dated 9th February 2015. Now, kindly see paragraph. That's why I placed your lordships paragraph 5 of the affidavit of compliance, 3, 4, and 5. So they have once examined one before the Supreme Court, and then they complied that we have complied with. They filed this compliance. Now they are taking up the another same thing, another. Just because the change. Kindly have a look at this date. That government also behind us. But kindly see that this has been done after change. Okay. These are my humble submissions. We point out one.
I am appearing on behalf of the managing committee in all 4 matters. I am appearing on 11, 12, 13, 14.
11, 12?
11, 12, 13, 14. In respect of all madrasa, I am appearing on the committee. Now I have to make some submission. Now, first of all, my lord, the issue relating to the appointment in respect of the all madrasa before your lordship has been, my lord, finalized by the Honorable Supreme Court. When the Honorable Supreme Court passed an order directing the authority to release the salary subject to the satisfaction of the eligibility criteria. This is the specific order of the Honorable Supreme as interim measures. Now, my lord, state government, after assessing the eligibility criteria, granted approval provisionally. Subsequently, my lord, the final judgment when delivered in respect of the Roping matter, paragraph 58, your lordship has seen that, therefore, has declared all the appointment of the petitioners in respect of that petition, SLP, Roping is deemed to be valid. Therefore, my lord, so far the Nazima judgment is concerned, this is the writ petition filed by the unpaid teachers, unapproved teachers. The petitioners in that matter has got no connection with Nazima Khatun judgment. Against the judgment of the Honorable Division Bench, now, my lord, the state government prepared the SLP. Now, we are made party there. There, the Supreme Court passed an order. Now, our appointment is deemed to be valid. And that has been finalized by the Honorable Supreme Court. Now, some unpaid teacher and unapproved teacher moved a writ petition challenging the report of the committee. There, the Honorable Supreme Court dismissed the writ petition. Now, I am putting question to myself that whether this judgment of Nazima is applicable to our case. No, because the Supreme Court when has finalized it and we have got no connection with the Nazima Khatun. Therefore, this judgment will not be applicable to us. And moreover, the letter which was issued by the Madrasa Board referring the judgment of Nazima, the Madrasa Board cannot issue that letter because so far the Nazima judgment is concerned, we are not concerned with that. And when the Honorable Appeals Court had finalized, Madrasa Board of what authority has got to reopen this issue? You cannot do that. This is my humble submission, my lord. No, that's it's a point of law. That doesn't. But I would summarize each of the points. If I find there is on a point of law substance, I will straightway say this part there is a substance in law. If I find no, there is a lacking part of it, I would say that. So because Now, if I formulate, my lord, first point, as I have understood from all my learned friends, have been very consistent. The consistent point is that if Shafiq judgment, directions, that approvals remain, if that judgment stands and not subsequently diluted, each of the submissions of my learned friends should stand as if the correct submissions on a point of law. I want to make a distinction in this way. If I can say again, my lord, my learned friend submissions that paragraph 64 of Rafiq has given them complete validity of their appointment and approval. I agree with that part. Now the point is whether Rafiq ended in Rafiq or deliberately the Honorable Supreme Court, after seeing 64 of Rafiq, wanted that 64 to be reopened in the light of whether all these appointments have been done following, if I can use X and Y. Because if I can give the context, commission was in a situations that cannot function because there is the declarations, it's ultra vires. So that's an extreme measure that the commission is not functioning. Now, does it mean that appointment can be done without following anything at all, or something is required to be followed? Now, whether something is required to be followed during that period, if I can use that slumber during that period, precisely that was the issue after Rafiq, when Rafiq was taken up in contempt matters. The contempt, that name is the Snehashish. There, for the first time, despite 64 apparent watertight approval, big legal stamp, despite seeing that the Honorable Supreme Court felt that our paragraph 64 cannot be given a watertight manner, we want a factual finding of correctness of the appointment. For that, a committee was constituted, and that was in Snehashish. Once that was done, after that, a writ petition independently filed before the Honorable Supreme Court. Well, I will go to the pages. Before that, I just want to give the specific points that I would be addressing. So first was the Rafiq. Rafiq gives them in fact, each of the arguments of my learned friends are absolutely right had there been no Snehashish and Najma. So therefore, my lord, my view is this. If I fail to satisfy your lordships to show that Rafiq 64 has consciously been taken up by the Honorable Supreme Court for some scrutiny, and that 64 can stand only upon following, let's say, X and Y conditions, and that's the judgment of the Najma, which is not in personam, it is judgment in rem, then, my lord, each of the points likely to fall flat. Now, if I can put a question to myself, the question would be whether Rafiq ended in Rafiq or not. I put a question, I will directly answer. So that's the first question. The answer I would not give, I will show from the judgment of the Honorable Supreme Court, because precisely that question was taken up by the Honorable Supreme Court, and the Honorable Supreme Court, kindly take Najma. In fact, if Rafiq had been the ending of in Rafiq itself, there would not have been any requirement on the part of any of the authorities to do anything at all. And each of the submissions of my learned friends would have been found to be correct. So, my lord, the first question is, Rafiq
did not end in Rafiq. Kindly take page 7 of Najma.
Yes.
And let N, Nagpur. Closure of the appellate proceedings triggered by the challenge to the Madrasa Service Commission Act did not bring about a quietus to the controversy. Rather, it was quickly followed by initiation of petitions alleging contempt of the directions made in Rafiq. The contempt petitions came to be decided by the two-judge bench presided over the Honorable Justice such and such in Snehashish. Then, my lord, paragraph 18 quoted. Accordingly, this court, exercising its power under Article 142, hereby constitutes a committee headed by Justice Devi Prasad De, retired Judge, Calcutta High Court. The committee shall also consist of such and such. Lordship may skip that. Now, kindly come. Next page. The committee is requested to consider the claims of the petitioners, keeping in mind the following. Now, A, B, C, D, E, F. Now, if Lordship kindly have a look at A, whether the madrasa or its managing committee was recognized by the state government on the date on which the appointment was made. Now, that was one of the questions. In fact, one very, it might be little shocking to my learned friends. Item 11 and 13. Precisely the same madrasa point was taken up by the Honorable Supreme Court in Najma, holding that was not properly constituted the managing committee, and therefore any appointment given by them stands void.
11 and 13.
Yes. 11 and 13. Now, I will show that. So all I'm saying from this, so this is, my lord, the first dilution.
But just
Yes.
before
Yes.
proceeding further,
Yes.
the last sentence records that the committee is requested to consider the claims of the petitioner.
Yes.
That means the petitioner in Najma.
No, this is
in Sneha.
Lordship is not saying Najma.
The Snehasis.
This is the quote. Na Snehashi. What is Snehashis? Snehashis is Rafiq. Snehashis is a name in the contempt proceedings arising out of Rafiq. Rafiq is the judgment my learned friends are relying on. So, paragraph 64 of the Rafiq, that protects him. I agree with that. Because when I look at the paragraph, I don't have any different view. Yes, paragraph 64 clearly says everything that gets approved, it can't be touched. Correct. But it's a judgment of the Honorable Supreme Court. Same Honorable Supreme Court from the same proceedings in contempt jurisdictions failed. No, this is not final. Our observations. We want some factual finding whether the appointments were actually given following X and Y. There are two notifications. While the commission was not in functions, it's not that they can do anything and everything. They have to follow certain procedures, and those notifications were issued. Now, Snehashish, this is the first step. Snehashish is the first step where the watertight effect of paragraph 64 on a point of complete protection became subject to factual finding to be decided by the committee. That was the first dilution. Second dilution was when large number of persons filed a direct writ petition. It was not an SLP before the Honorable Supreme Court. There, the Honorable Supreme Court took up this issue and clearly said, my lord, I was first in page 7, paragraph N. That the second line.
I was putting the question
yes.
that the committee is requested to consider the claims of the petitioner
Yes.
in Snehashish Giri has been quoted.
Yes.
Is it so that it is restricted to those petitioners who filed the contempt application and the managing committee or the approval of the managing
No.
committee was to be gone
No.
into, or overall the situation has to be
Yes.
looked into?
My precise answer was it was for overall. Well, I will show that why I'm saying so. It was for overall.
Okay.
It was
Not
for
restricted to those petitioners.
yes, it is not restricted to the petitioner. It was supposed to be overall.
Okay.
Should I now? Well, the second line of paragraph N, the entire submissions of my learned friends have been that Rafiq is the end. The answer directly, second line, did not bring about a quietus to the controversy. Therefore, this is not the ending of the controversy. Rather, it was quickly followed in initiations of the petitions alleging contempt. So, which precisely I was saying. I could have understood there is a full stop of it, no difficulty. So, that cannot be touched it. Now, the Honorable Supreme Court, in the latest judgment, recording that Rafiq was not the end of it. It went to this contempt proceedings and the committee. Now, after that, kindly take paragraph 15. Now, paragraph 15 is a very interesting paragraph. In fact, I was thinking, because each of the submissions which has been taken as the fundamental submissions on behalf of the petitioner happen to be the submissions before the Honorable Supreme Court. When I read it out, Lordship will see, Lordship will find it's exact echo of the same submissions. What was the submissions? Rafiq is watertight. Therefore, Rafiq stands on solid ground. The Honorable Supreme Court is answering, dealing with it. I'm taking the exact words. No. If you rely on Rafiq only, minus following two notifications, you are not standing on the solid ground. You are standing on the sand. Precisely. That Lordship will find paragraph 15. Prior to
Yes.
Prior to looking into the claims of the screened individual petitioners, we need to deal with an argument advanced by Mr. Roy. In fact, Malad, this Mr. Roy's submissions is exactly the same submissions of all the councils, which, however, no other learned senior counsel appearing for the other petitioners advanced. Referring to an observations made in paragraph 64, that's the watertight 64, of the court's decisions in Muhammad Rafiq, Mr. Ray contended that the whole exercise undertaken by the committee was unnecessary, since all appointments made after the decisions of the single judge in Kontai Ramania High Madrasa have to be treated as valid for all purposes. Rights of the petitioners had crystallized in pursuance of the binding directions of this court, and therefore he submitted that it was too late in the day for the respondents to deny the petitioners the benefit of the same. So therefore, what she finds, it is same. Now next paragraph. The same contention was urged by Mr. Roy before the coordinate bench deciding Snehashish Giri. Such contention was negatived in the following words. Thereafter quote. In para 64, the court in Muhammad Rafiq case declared the nominations by the commissions in pursuance of the provisions of the act as valid, and the appointments made after disposal of the matters by the High Court as deemed to be valid for all purpose. However, there is no discussion with respect to whether the court had applied its mind as to how the madrasa had proceeded to appoint teachers as teaching and non-teaching staff. Also, there is no discussion regarding rules, regulations, applicable circulars and guidelines in terms of which aided and unaided recognized institutions could make appointments, having regard to the standard of education required and the requisite experience. Whether a transparent method was followed, whether the madrasa concerned was recognized one or not, this is also extremely important. Whether the committee or body selecting the individual was constituted in accordance with the rules and regulation, etc. The argument of the respondent alleged contemners that there ought to be an exercise of verification, therefore, appears to be merited and substantial. Thereafter, in the present case too, this court is of the opinion that the respondents stand that without verification, kindly mark this, without verifications of the petitioner's appointment and whether the procedure prescribed were duly followed in respect of matters such as fulfilling eligibility conditions, essential qualifications, relevant experience, availability of vacancies, staff pattern in respect of madrasa, where recognition was granted, and if so, for what period, whether the institution was aided and recognized or not, or recognized and not aided, and if so, for what duration, whether a duly empowered selection body or bodies considered the candidature of the claimant before he or she was appointed, and whether the committee or body selecting the individual claimant was constituted in accordance with the rules or guidelines, etc., is justified. In these circumstances, this court is of the opinion that further proceedings cannot be continued as no determinations can be made unless there is a, kindly mark, due verifications in regard to the employment of each of the petitioners. Kindly straightway thereafter come to 17. It is therefore clear as day that the observation made in paragraph 64, but that is there the best submission of Muhammad Rafiq relied on by Mr. Rai was duly considered in Snehashish Giri and bearing in mind the factors referred to in extracted passages. Further directions were issued regarding constitutions of the committee for verification of the claim. On the point as to whether the appointments are valid or not, the directions in Snehashish Giri constitute the kindly mark this. The directions in Snehashish Giri constitute the binding directions with each party to the lease is now bound to follow. Building a case, this is the ultimate metaphor. Building a case, placing reliance on the said observation of paragraph 64 of Muhammad Rafiq in the chain circumstances is like building on sand. To rest a claim on such observation is to mistake a whisper for authority. We thus have no hesitation in rejecting this argument of Mr. Roy as misconceived. May I continue after? No, I can continue. I have no difficulty.
Fixed matter আছে এখানটা কি fixed আছে
Well, for the purpose of interim order, I can finish today itself. I will not take much time.
Hearing আছে you are intending to file in opposition to the
Well, this is purely point of law. Nothing is required. No, there is no requirement at all. Once I, most likely, I'm saying I'm not confident, but most likely, once I show, because Lordship may kindly see, I am not trying to avoid their points. I am acknowledging their base case is 64. I am only adding that what is their base case, that exact point was taken before the Honorable Supreme Court, and thereafter the Honorable Supreme Court clearly said that regardless of 64, 2 points have to be satisfied. Once I show that, and thereafter I will straightway come to the direct point that on a point of show cause, when regardless of anything, if someone is asked, come with a document for a hearing, there are any number of judgments by the Honorable Supreme Court, our High Court, saying this is absolutely premature, because asking a person, today Najma is Article 141, it's not in person name. And Najma says, when commission was in slumber, it's not that you can appoint and thereby Nothing has to be followed. In fact, there are 500 and odds. They lost. Some of them were getting salaries. All they lost. Now, the Honorable Supreme Court clearly clarified. Show that you have followed notification. There are two notifications.
Okay, February 20.
No one is questioning that you can't do it. The only question is, have you done it following it? To ask by the authority, have you done it following notification 1 or notification 2? Most likely, it would be absolutely premature today itself. I can understand that tomorrow if there is a judgment, because context is around 500, the Honorable Supreme Court found that they are not entitled to and therefore they lose and they have lost. Out of that, there are two madrasas they lost because that managing committee was not even a managing committee. That is also two matters. Other matters, only question is, Lordship, I would not be requesting your Lordships to enter into the merit of it. Only question.
Only distinction they are drawing that they
were approved.
They were not the persons as of now.
I would.
And the state, by issuing that letter,
that
is trying to reopen
correct,
the fresh case.
correct.
That is the.
That's the. I would say that's a brilliant argument. That's a brilliant. Had I been in that other side, most likely I would have said that. That's the reason I begin my submissions from the point, assuming there is nothing after Rafiq, whatever they say is absolutely correct. But because the Rafiq 64, that has been not only diluted, today's 64 means this. Today's 64 means if that appointment has been given not following notification 1 and notification 2, that appointment goes. And today that is not even the situation. Today's situation is that the provisional approval which was given, kindly look at the technical point. All of them are referring to Rafiq. And they say, yes, they agree it was the provisional approval, but that was subject to SLP number is Rafiq. But they say, because that numbering was of Rafiq, therefore, jurisdiction has to be within the Rafiq itself. But the Rafiq itself has extended in Sneashish. And Sneashish itself has extended in Najma. And today, 13 July, is the Najma is Article 141 steering. As an authority, if I ask, please let me know whether you have followed notification 1 or notification 2. I don't think Lordship would hold that authority can never ask that give me the documents. May I continue after 2?
Lordship, the past over matter, item number 6.
In the afternoon, after I come back, you will continue.
Yes, I'll continue.
Continue here, Rako.
Lordship, the past over matter, item number 6.
For the so I need to supplement much to what Mr. Dhor says. I don't need to, but on behalf of the state, whatever.
But this is the pure point of law. And one thing I should say,
I'm asking you whether at this stage, after hearing you,
correct.
Because again, placing it for affidavit, if you don't file
No.
opposition,
Lordship may record. Lordship may record.
Present situation after the proposition laid down by
Correct,
the Honorable
correct.
Supreme Court,
Correct.
whether this can be disposed.
In fact,
On a point of law.
one thing I should very candidly say, it is nothing about the change of government, nothing about that. But when a statutory body is created, it is expected that it should function with its full vigor. For some reason, keeping an authority in a slumber mode, I'm not alleging anything, just on a point of context, keeping some authority in a slumber mode and thereby doing XYZ, which are highly illegal, could be a question which doesn't give any right to any person. Hello, I will come back.
Lordship, the past over matter, item number 6, may it be taken at 2 p.m.
No, this matter is
Yes,
Tomorrow.
Tomorrow, Lordship. Great.
One day.
My lord, I was at paragraph 17. Najma.
Yes.
In fact, I was reading entire paragraph 17 again during the recess, and I felt that the entire points, whatever has been taken by the counsels for the writ petitioners, precisely that has been answered in 17. There is a metaphor also that it was, if I can just read 17, and it is therefore clear. This is, every word is so correctly chosen. It is therefore clear as day that the observation made in paragraph 64, which is they were saying entirely, of Muhammad Rafiq relied on by Mr. Roy was duly considered is Nehashi's giri. This is the first dilution. And bearing in mind the factors referred to in the extracted passages, further directions were issued regarding constitution of the committee. Therefore, this committee is now extension of the Muhammad Rafiq. Muhammad Rafiq, Nehashish, this committee. Further directions were issued regarding constitution of the committee. But this is for verifications of the claims. On the point as to, now I pause for 1 second. For verification of claims of whom? If I put a question to myself, the answer is the simplest. Whoever is the beneficiary of 64 of the Rafiq. The next question will be, what does it mean? It means anybody who claims the benefit under 64, like the petitioner. My lord, this is applicable for them. In other words, my lord, sometimes when we look at in a very technical way, that this is the judgment and this is the Rafiq judgment, and therefore this is the benefit. But that is not seen in its full context. The context is the Rafiq was an ongoing which ultimately ended on 13th of July. Fortunately or unfortunately, whatever it is. So if someone talks about Rafiq, if someone takes benefit of the Rafiq, he cannot just say Rafiq, because Rafiq today is no more Rafiq alone. Rafiq is the beginning, because I was trying to understand why the Honorable Supreme Court took a turning from Rafiq. There was a very justification. Justification was this. Rafiq was primarily, I would say, the 90% of the energy was whether fundamentally the legislation was ultra vires or not. So as an offshoot, what happened during this slumber, the Honorable Bench actually did not look into other aspects. So therefore 64 came. That was realized by the Honorable Supreme Court in the Rafiq's contempt in Sneashish. And therefore, under Article 142, created the committee and wanted that committee to see. And that committee, what happened?
Yes.
The committee gave a publication asking everyone who wants to claim the benefit of this approval appointment, they should come to the committee. Now, interesting chapter is this. Around 500 of them, they went to the committee. In fact, their situations are absolutely similar, like the petitioners. The petitioners, they felt confident. They did not go to the committee. So difference is, the committee was not like that. The committee will do a roving inquiry of their own. Committee said that if you want to get a benefit of Rafiq, because of the extension of Rafiq, now it is you have to claim. Now they were silent because they were getting the benefit. Otherwise, that's why they were silent. They never went to the committee at all. Around 500, they went to the committee. And the committee found that they are not fulfilling the conditions which were required. Therefore, this is not proper. Once this was said, around 350 of them went to Honorable Supreme Court directly filing a writ petition under Article 32. Interims orders were passed, so their salaries and other things were protected, and that continued. And that culminated in Najma 13th of July. So therefore, paragraph 17, today Lordship is hearing the writ petition. Now, if a point is taken before the Honorable Supreme Court, as in previous to paragraph 17, and ultimately culminated in 17. Well, if I now go to rest portion of 17, further verifications were issued regarding constitution of the committee for verification of the claims. On the point as to whether the appointments are valid or not, the directions in Snehashish Giri constitute the binding directions. Now, I again put a question to myself. The direction of Snehashish for whom? The direction of Snehashish is for whoever claims the benefit of Rafiq. Binding directions which each party to the lease is now bound to follow. Now, next is the metaphor. The building a case, placing reliance on the said observation in paragraph 64 of Muhammad Rafiq in the changed circumstances. Changed circumstances is the dilution step by step. I wouldn't say dilution, I would say precision. There was one time, little out of context, something has been said by the Honorable Supreme Court without looking into the factuals and the legality, which was acknowledged, and therefore a precise directions on factual thing. That in the changed circumstances is like building on sand. To rest a claim on such observation is to mistake a whisper for authority. Well, kindly see the metaphor. What is whisper? Rafiq 64 is the whisper. And what is the authority? Snehashish's directions, precision, factuals, that's the authority. That the beautiful language, it's a look like a music. So today, my learned friends, if I borrow the language of the Honorable Supreme Court, relying on 64, they are relying on the whisper, which has culminated in an authority, and thereby I clearly borrow, they are actually standing on sand. But I don't say that they don't fulfill notification 1. I don't say that, because today that's not the situation. All I say, to say that I am not required to show that I have fulfilled notification 1 and notification 2 because of 64 is clearly standing on the sand. I think, my lord, this fundamental point, it's not my argument. It's a clear answer by the Honorable Supreme 70, and that puts an end to it. And under Article 141. So they cannot really re-argue and seek from your lordships to decide something which has already been decided by the Honorable Supreme Court. Now, now, in fact, kindly take, my lord, paragraph 19. Every word is so chosen this time. Paragraph 19, since either notification 1 or notification 2, was required to be followed. So that's the understanding. Prior to that, by the managing committee of the recognized and aided madrasa, it would be worthwhile to note the relevant clauses. So therefore, kindly, your lordship, kindly see the step-by-step clear-cut answer of the Honorable Supreme Court. The Honorable Supreme Court, having said that you are standing on the sand, if you simply rely on 64, that was not a full stop. Even thereafter, what is to be done? There also there is an answer by the Honorable Supreme Court. Paragraph 19, what is required to be followed was notification 1 and notification 2. After that, from paragraph, kindly take my lord, paragraph 23.
23 years.
In fact, paragraph 23, what has been decided precisely for a particular madrasa, they have not disclosed in one of the matters. They are effectively asking a directions which is decided. Kindly see my lord, paragraph 23. Paragraph 23, because what the, if I can give the my lord, context, since there are 350 petitioners before the Honorable Supreme Court in out of 49 writ petitions, all tagged together. The Honorable Bench wanted that, I understand that you want to demonstrate that you are properly appointed. You choose 10 based of your case, so that we don't have to labor for each and every one, and so that we don't have to see the worst case. So the councils were given time to choose that there are hierarchy of, we all know that this is the best point, this is the not so good point. So the all counsel for the petitioners, they chose the 10 best. Oh, 13, I stand. So 13, in one place it was mentioned 10, but I'll correct. Ultimately it was 13. So that 13 best cases were placed in its entirety on factual, law, whether requirement of notification 1, notification 2. But that 13 cases was not for 13 alone. It was for the purpose that the Honorable Supreme Court would be deciding a law point. What was the law point? Law point was, when the commission was not functioning, whether anything was required to be followed. So this is, according to me, clearly a judgment in rem. A point of law is decided that at that juncture, notification 1 or notification 2, that is required to be followed. And interestingly, this is factual. 23A, kindly see the name. Name of the madrasa is Jimageria Welfare High Madrasa, 23A. I found that this is 19902, কত নম্বর item দেখো? Item 11. Kindly see the respondents. Lordship will find. I have checked it.
11.
This is Bimal Hindu. Respondent number 6. Lordship has found. Now kindly come back to Najma. In Najma, for the same exact madrasa, the Honorable Supreme Court found the committee itself was not authorized to issue any appointment letter. Right, wrong, it is immaterial. I put a question to myself. Once for a particular madrasa, authority has been questioned, the Honorable Supreme Court found that madrasa, that committee, they don't have an authority. Can in a writ petitions, though they have not, they should have disclosed it, they have not disclosed. Can, my lord, your lordships in Article 226 revisit that? Now, in this context, when your lordships look at the impugned order, I will place it at the last. Now there are large number of madrasas. This is one example. Now today, if we have not thoroughly checked it up, seeing the name, seeing the judgment, everything, we would not also been able to find it out because it is so factual. So therefore, factually, this is required to be seen. What are the name of the madrasas? Out of which madrasas Honorable Supreme Court have already decided that these committees have got no authority. And there are, for some other madrasas, different reasons. Now, the authority state needs to see, and that's the reason the hearing and asking for the documents. Well, this the 23A, Lordship has got the name, and kindly see 23B.
Yes.
23B, in course of hearing, it transpired that there was no valid managing committee in existence on the date this petition came to be appointed. An ad hoc managing committee constituted, thereafter elaborately reasons have been given. In fact, there is another matter also, that is item number 13. There is a Majna High Madrasa. There also, Lordship need not see it, because this is an example. My endeavor is this, that the Honorable Supreme Court took pain to actually factually decide 13 cases. Does it mean that the Honorable Supreme Court wanted that the law point that has been decided by the Honorable Supreme Court, that is notification 1 and notification 2, that is not required to be seen for any other madrasas? Because the entire argument of my learned friend, you cannot touch me because of 64. My answer is that is a self-contradictory, because they cannot stand on this argument because of the judgment they are relying on. I don't have to go to a separate judgment. The very same judgment in a contempt proceedings, different mechanisms were formulated. Ultimately, Najma was in, everything was considered, and it was found that notification 1 and notification 2 contains several aspects. Those are required to be fulfilled and seen. And now, kindly see. Kindly take.
Have you checked up one thing, that this
Yes.
Jimaj area welfare, at the time when these petitioners who are before this court,
Yes.
at that point of time when the appointment letters were issued to
Well, dates,
validity was there.
well, I would have come that point. There is an interesting 3 dates. Kindly, take these 3 dates. Page, well, I'm referring to the first, the lead matter is the first one, the item 10. Kindly take the item 10 petition. It's very interesting. First, Lordship, kindly keep side by side Najma, page 5.
Yes.
First, kindly take the first date from H, 14th March. So if I can read, in the aftermath of these developments, proceedings commenced before this court, this is Supreme Court. The judgment and order dated 9 December 15 of the division bench, upon a challenge before this court in a special petition by Muhammad Rafiq and others, a coordinate bench by its order dated, kindly mark this, 14th March 2016, stayed the operation thereof during pendency of the such. So meaning thereby 14th March 2016 as an important date, where the Honorable Supreme Court, for some reasons, stayed the operations of the Honorable High Court Division Bench judgment. So March 16. Now kindly take their approval at page 153. Or 154. This is November. So 28th November 16. So this is, well, there was a window when the recruitment could have been done. Window was prior to stay granted by the Honorable Supreme Court and the High Court declaring it to be ultra vires. So this is the window. If I can say this, there was a legislations. Commission has the exclusive authority. The moment it is declared ultra vires, that day is the starting window. The finishing window is when the Supreme Court stayed it. So this window, some recruitment have happened. State also recognized it. But state wanted that during that period, you have to follow, there are two notifications. Either notification 1 or notification 2.
So now we are concerned with 9 December 2015 to 14th March
16. Yes.
In between this period, some of the madrasa, the managing committee has given
Now,
support.
I take their side. Their contention is page 154. Kindly take my lord 154.
Yes.
They would probably say that November is the approval, but the date of appointment, kindly have a look at the date. 12th of March 16th. So the magical time ended 14th of March. It's very interesting. Magical time ended, or the if I can use the proper words, the madrasa's own authority to recruit, that ended on 14th of March. Now, Lordship finds the entire date of appointment all 9 or 12th of March, just 2 days before. I'm not saying whether it is backdated. I'm not saying it because this is not the time to say that. But the Honorable Supreme Court in those 13 matters found that hurriedly in a giving back dates and variety of illegal process, this has happened, for which 350 candidates, the Honorable Supreme Court declared, if you have not fulfilled notification 1 or notification 2, then you cannot claim, regardless of whether you are enjoying an interim order, regardless of whether 64, there was some direction protecting you, because that 64 has already been taken a different shape altogether. Now, kindly, there are 2 more interesting dates. 14th March, well, I have given the date, that's the ending. 14th March is based on 5H. 5H is the Najma. Because I am only showing which is already been decided. It's not that submission. This is, I'm showing what is decided. So 14th March, because of the 5H, it cannot be diluted. Now the question is when notifications came. 2 dates. February 15, 9th of February, Lordship may kindly take these 2 dates. 9th of February 15, first notification. In fact, Lordship can take the Najma G, just the one G. prior to and post the said judgment and order of the division, when the state government had issued two notifications dated 9th February 15 and 4th March 16. So therefore, 9th February and 4th March 16, two notifications. These two notifications are required to be followed. Why do I say it is required to be followed? Because ultimately, why do I say this is to be followed? Because ultimately, following and considering all the previous judgments, in Najma, the Honorable Supreme Court declared the law that this has to be done. And for those, as a sample, those not done, they lose. Once, my lord, that has happened, in the light of that, kindly take, my lord, 166.
Can you just once again indicate that paragraph and notification 1 and 2 has to be followed? That
Yes. I'm
19.
Correct. I'm showing. Yes. My lord, this is no, the notifications, my lord, referred at G, 5G.
Yes.
And these are required to be followed. Kindly straight away go to 19. Was required to be followed. But this is REM. Today, if your lordship decides for XYZ post, 1 and 2 are required to be followed for an individual case, that is not a judgment in personam. That is required to be followed. That's a judgment in rem that is required to be followed everywhere, whoever is claiming the similar thing. The only exception could be this, because for the time being, I should also see the whether there is some merit in their submissions. If they have merit in their submissions, what would be the consequence? Consequence, I'm thinking from a legal point of view. The only consequence would be what my learned friends are trying to say, that the recruitment by the madrasa, which was done during that slumber period of the commission, that can be done without following anything. Why? Because we have got a seal in paragraph 64. That, I think that can, if I take it the highest, that is the ultimate thing. Because today, if this stands that the Najma is only for that 13 persons and 350 persons, it is not a judgment in rem, it is only a judgment in personam, then only meaning will be this, that there was a period when the recruitment was done. Recruitment was done by the different madrasa. For them, it is like whatever they want, or they have to follow notification 1 and 2. My respectful submission is that there is no scope of interpretation, because the Supreme Court exhaustively quoted, referred, not only 19, there are several paragraphs. In those individual 13 cases, those have been rejected because, in fact, my lord, in paragraph 20, kindly take 20 onwards, 19 said that it has to be required to be followed. 20, all details of those notifications are given. And kindly come to thereafter, just above 22. That or 22 itself. Let us now test the substance of the petitioner's claim as projected before us by learned senior counsel. Each of the claim is proposed to be dealt sequentially. So therefore, this is the notification number quote. Then these notifications are required to be followed. That's the point of law decided. Then was it followed for them? That has been done for 13 and effect has been given that for all 350. Once that is done, this is, my lord, a law which is required to be followed by the state, by every authority, because this is the law regarding the recruitment for that during period. And because of that reason, my lord, kindly come to 166.
All the petitioners in all the writ petitions are being appointed within that period.
That window.
Yes.
That is the window which
Yes,
they are taking
yes,
advantage of.
In fact, if anyone is appointed
Prior to 9 February.
there are two situations. Somebody says, I have a different case versus I have a better case. But this is little why I say this. One can very well say that I have a different case. I say fine, it's a different. A different in what sense? Is it actually a better or worse? If somebody is not within that window, then the Madrasa Service Commission Act, he would be hit by that. He can't claim any kind of appointment. So therefore, whatever little life, whatever little, so that could be, that's what I'm saying. It's sometimes some words are, it sounds nice that my case is different. Well, it's different, but does it mean it's a better? If you are beyond different and without the window, in window there are two sides. One side is stay of the Supreme Court. One stay, you are out of the window, therefore your case is different, means your case is worse. Your case is worse. You can't even you can't follow. You don't have a, it's like you don't have jurisdiction. And the beginning window is when it was declared ultra vires. If someone does it even beyond that window, that is a worse case. So making submissions, I have a different case from the persons who are before the Supreme Court because of XYZ reasons or because of the beyond window this, that doesn't help them at all. The only way which can help them, it may, if they can demonstrate that now there is a law by the Honorable Supreme Court that notification 1, notification 2 be followed, and the authorities have asked for that, they show that we have actually followed it. Matter ends. They cannot make out a third situation which sounds good but effectively which is worse. Now, 166, what they have challenged. I have a very word which is very cliche word, but I don't have a better word. This is absolutely premature. I have brought the judgment on that. The line of judgments are like this is, may I just first place it? 166, subject notice for personal hearing and production of original records, documents in connection with the recruitment process followed by appointment of teachers for whom approval for provisional appointment and release of salary was accorded. Now, while reading this, Lordship is also required to read 153 first and thereafter 166. Kindly take 153 or 154, same.
Yes.
Or I would show both. 153 last paragraph. The release of salary for the period for which they have performed their duties will continue is subject to further orders of the Honorable Supreme Court in this respect. Since the eligibility of the above named staff to their engagement in madrasa could not be determined, can you mark this? Due to the ongoing proceedings of the Supreme Court, it shall not be a precedent for any case before any madrasa and will also not prejudice the state from examining the issue subsequently. So therefore, this is an approval which can be said to be provisional approval, protecting the rights for actually verifying, examining later on once it is finally decided. And 154, kindly have a come to 154 when the last after the table, the line. This is a super hyper technical point. This approval of appointment are accorded subject to the final decision of the Honorable Supreme Court. Now this is the number. 6661 of 6, that's the Rafiq. So all my learned counsel's entire submission is, it means it is confined to Rafiq alone. I say yes, but if the Rafiq itself actually extended by the Honorable Supreme Court, so it actually goes there only. Sorry. So in that light, now kindly come to 166. Why did I say it is absolutely premature? Well, in compliance with the verdict dated 13/7/2026, well, I pause for one moment. I think the first question is, where is the directions of the Honorable Supreme Court? My direct response to that, when a law point is decided by the Honorable Supreme Court, every authority in the country is supposed to comply that. I, as an authority, cannot just say that, no, I will take my own decisions, I will go in a different manner. So therefore, in compliance, because of the Article 141 binding nature, there is no requirement of the Honorable Supreme Court to give every direction to every madrasa all over that's not required. Once the law point is decided, it is for the authorities. If they don't do, but that's a different chapter. In compliance with the verdict dated such and such, passed by the Honorable Supreme Court of India, such and such, relating to recruitment, appointment of teaching, non-teaching staff, whose names are mentioned in the copy of this notice itself, in some non-government aided madrasa, this office requires to verify, kindly mark this. So this is in consonance with 153 reservation of examination and verifications. Even otherwise, the Honorable Supreme Court judgment, we could have done it. But the state thought it is always better to see, maybe the Honorable Supreme Court wants that, no, you don't have to do anything. There is nothing like that. The Honorable Supreme Court, they themselves took the pain of verifying in the line of notification 1 and notification 2. Therefore, the state cannot put itself higher than the Honorable Supreme Court as if they have a separate rule altogether. To verify the validity and legality of the recruitment process followed by issuance of appointments by the concerned managing committee in the light of the aforesaid judgment. Well, this is in the light, that's the judgment in rem. The guidelines laid down in order number dated 9/2/15 issued by the School Education Department, Government of West Bengal, and the notification number such and such dated 3/3/16. Well, I will pause for one moment to show the fairness. Authorities are not referring to something of their own. They are not saying, today we are coming up a new notifications, you have to comply with it. No. Existence of the notifications were there prior to their appointment. Examination and verifications could not be done. Provisional approval, salary, everything were given. Now Supreme Court has given the clear law. We also reserved the state also reserved their right in that juncture. This is, I could have understood that mala fide can be attached if I come up with a new notification and now I say, by changing the rules of the game, that you have to follow this. No. What was already there but not verified.
This date is 3rd March 2016.
Yes.
This is a separate notification or
Uh,
4th March? Separate.
3rd March 16, but it could be separate, but so this is for the same purpose, because well, I'm not required, neither lordship would be required to enter into that how. It's a question of propriety. It's a question today is can they? My point is, it is so fair that they are not coming up with a new notifications and saying that we want to do it now on the basis of new notifications. They say that there are old notifications are already there. So we need it to be verified post this judgment. And for that, and then my lord, second paragraph in this regard, this is to request you to please attend this office on 6th of August with all relevant testimonials, paper, documents concerning recruitment process and the eligibility criteria of the teaching, non-teaching staff of your concern, in whose favor provisional approval for appointments release salary is granted subject to the verdict of the Honorable Supreme Court to relevant. Now this, according to me, is nothing but a show cause. Similar to show cause. Now, well, kindly take this judgment. 2006, 12 SCC, 28, paragraph 14. But paragraph 14, the reason why the reason why ordinarily a writ petition should not be entertained against a mere show cause notice or a charge sheet is that at that stage the writ petition may be held to be premature. Now, well, I say, just like my learned friends, my case is different, but difference in a sense even better. This is a situations where there is no judgment of law decided by the Honorable Supreme Court. Even then, a simpliciter show cause, a simpliciter asking, please come for the hearing, please give me the documents. That is permissible. That is usually lordships do not interfere with that. But here it is judgment by the Honorable Supreme Court being binding under Article 141 and post judgment the proper action of the state to examine it, which they preserved in the provisional approval. So even my case is better, but even otherwise proposition of law. So, and the other same point, this is 2019 20 SCC 446.
Which paragraph?
Well, there are two paragraphs, but basically I would be relying on paragraph 31, but also little bit of 30. If I can start with 30 and 31.
Yes.
On the other hand, we find force the contention of the learned senior counsel, Sri such and such, for the appellants that the High Court has committed error in entertaining the writ petition under Article 226 of the Constitution of India at the stage of show cause notices. Precisely as you're saying. And 31, Lordship may skip 1, 2, 3, 4, 5 lines, Lordship may skip. Placitum, just above placitum D.
Yes.
When there is a serious dispute with regard to classification of service, the respondents ought to have responded to the show cause notices by placing material in support of their stand. May I kindly read serious dispute of service. Kindly read as serious dispute having been found by the Honorable Supreme Court in respect of large number of persons of 350 and by the committee by 500. Well, this is on that. No, no, not necessary. Now, only that why I say that this is what are the- this is not a judgment in personam, this Najma, it is in rem. First, kindly take 2016. Sorry, not 6. এটা খুলে দিয়েছো কেন? Okay. Okay, kindly take 2021 2 SCC page 1. It's a larger bench. Well, I since it was searched only in the recess, so I could not. Usually, I always go with a printout. But I will give the printout later on. But since it's for a very short point is necessary, 48. Well, a judgment.
Yes.
A judgment in rem determines the status of a person or a thing as distinct from the particular interest in it of a party to the litigation, and such a judgment is conclusive evidence for and against all persons, whether parties, privies, or strangers of the matter actually decided. Therefore, if this is a judgment in rem which is about the window and how within that window recruitment is to be done, whether someone was there before the Supreme Court, it doesn't matter. It would be applicable for everyone like that. Because, well, the next line, as strangers of the matter actually decides, such a judgment settles the destiny of the res itself. So on subject matter, it settles the destiny. So today, I think nobody can question that, no, in my case, notification 1 is not required to be seen. In my case, notification 2 is not required. That cannot be said because it has been settled. And that settling of law is judgment in rem by the Honorable Supreme Court. Only one more judgment exactly on this point. This is 2016 SCC Online, Madras 26537. Where is Lordship, kindly take paragraph 28. Lordship may take paragraph from 27 itself.
Here.
27. Appointment to a post can be made by any of the modes: direct recruitment or promotions, or by transfer from one service to another. Appointment can also be made on deputations. In all cases, the appointee has to satisfy the relevant rules. Then, in that context, merely because SKM Haldar's case was decided dealing with a case of promotion, it cannot be contended that the said judgment is not applicable to direct recruitment. Precisely that. Merely because you were not, that doesn't matter. It would be applicable. And thereafter also, Lordship may kindly have a look at next page. There is a quote, paragraph 28 and 29.
Yes.
28, the judgment in rem signified as judgments which are good against all mankind, and judgments in person signify the judgments which are good only against the individuals who are parties to them and their privies. The point adjudicated upon in a judgment in rem is always as to the status of the res. Now that's the subject matter. So on that subject matter window, this is the judgment, and is conclusive. Now that's your and is conclusive against the world as to that status. Whereas in a judgment in personam, the point, whatever it may be, which is adjudicated upon, not being as to the status of the res, is conclusive only between the parties or privies. So practically, as I have said, the Honorable Supreme Court in Najma judgment has finalized what began in Rafiq. But these are my respectful submissions. So I pray that this 166, which they have challenged, and that is premature. Well, only last one thing, I have said it. I believe Lordship has taken note of that paragraph 23b, there for the exact madrasa, because it is very difficult, my lord, even for us also to find out which madrasa, what point is there or not. So that was decided. In fact, 23b, after Supreme Court decisions, effectively they want a rehearing of the Supreme Court decision. These are my respectful submissions.
এটা দিয়ে দিন। Yes.
My lord, now extensively Mr. Dhar has presented, my lord, before my lord. My lord, so my lord, my lord, I am speaking vis-a-vis, my lord, item 10. Now, my lord, this is similar. We will go one by one, my lord. So primarily, my lord, they try to situate themselves saying that they do not fall within notification 2 of Najma. They are guided by notification 1 as stated in Najma. My lord, in paragraph 17 of item 10, my lord, they have stated, my lord, that is Tariqul Molla, my lord.
Yes.
My lord. My lord, paragraph 17 at page 19, my lord, they've stated, it is stated that the respondent state notified the recruitment procedures for the non-government recognized aided madrasas 2016 in the official gazette on 3rd March 2016. However, since the recruitment process in the respondent number 8 institution commenced prior to 3rd March 2016, that is on 23rd January 2016, the recruitment procedures notified on 3rd March 2016 are not applicable to the recruitment of the writ petitioners. Now, my lord, if something is not applicable, something else has to be applicable, my lord. So, my lord, even taking their case, my lord, on face value, it is, my lord, notification 1, that is a 2015 notification, even as per their case, has to be applicable. Well, they are saying this act will not be applicable, well and good. Notification 2 will not be applicable. Although, my lord, the veracity of when these appointments were made, my lord, we will come to a bit later, my lord. So, notification 1. So, my lord, the first limb of my argument is, my lord, that they will have to abide by the conditions laid down in notification 1, my lord, which is the 2015 notification. My lord, I will come to that. So, my lord, essentially, they are saying that even as per, my lord, that notification 2, which I believe, my lord, they've also annexed, my lord, as per notification 2, my lord, which, my lord, they've annexed, and which is also, my lord, I have a copy of it, my lord, clause 17 of notification 2 is very clear that prior appointments were to be made as per the earlier notification, my lord. My lord has seen, my lord, that, my lord, I will place for my lord's convenience. অ্যানেক্সও করা আছে, তবু আমার কাছে কপি এনেছিলাম। My lord will be pleased to take, my lord, the 3rd page, my lord.
Yes.
My lord, clause 17. Statutory obligation. The state government in the minority affairs and Madrasa Education Department or the Director of Madrasa Education or the District Inspector of Schools, primary, secondary education concerned, shall not take any financial responsibility for any appointment if made in violation of these procedures. Recruitment procedure initiated before this notification shall be completed as per provisions of the order number such and such dated 9/2/2015 of the School Education Department. Now, my lord, the notification 1, which they have not annexed, as per the notification 2, that is a 2016 notification, clause 17, my lord has seen, notification 1 should apply. But notification 1.
So notification 2 date is varying with what has been stated in the Honorable Supreme Court's order. It's 4th March 2016.
My lord.
And the later records 3rd March 2016. These are two distinct.
My lord, this is the same. That's what we've been, my lord. My instructions, sir. My lord, my lord has seen, my lord, it was on, I believe, my lord, the Supreme Court's, my lord, the initial stay, and my lord, my lord is looking at the window in that case, my lord.
Yes, the two notifications which have been mentioned in Najma.
I'll come to Najma. There, my lord, we will. Very well, my lord, keeps this aside for a moment. Then I will come to Najma. I think that will, my lord. My lord has seen Rafiq, my lord. I will not place it, my lord, for any more, my lord. This has already been placed before, my lord. So Rafiq was disposed of on 6th January 2020, my lord. It was held that the act is intra vires. It is not unconstitutional. Section 7, 8, 11, 20, my lord, 12, 20, my lord. My lord, last two paragraphs of my lord Rafiq, if my lord will be pleased to take. My lord, very well, my lord. Rafiq, my lord has seen.
May I just, there is no confusion on date. There is a gadget. This is the, it was gazetted on 4th March, but notification date was 3rd.
Page 19. Thank you. All this thing. Because in interim order that was passed in Rafiq,
Correct.
it records that whether they have complied 3rd March 2016 or not.
Correct. But I was, in fact, I did not have a satisfactory answer. So while sitting, I was trying to see. Also, it is because sometimes some judges refer to certification, sometimes
Great.
Yes.
So, my lord, will be, my lord, paragraphs, my lord, 63 and 64. My lord, in the premises, my lord of Rafiq, just to place, my lord, in essence, what Rafiq said, my lord knows, in the premises while allowing these appeals, we set aside the view taken by the single judge and the division bench of the High Court and dismiss writ petition number such and such and other connected matters. We hold sections 8, 10, 11 and 12 of the Commission Act 2008 to be valid and constitutional. In the end, we declare all nominations made by the Commission in pursuance of the provisions of the Commission Act 2008 to be valid and operative. However, if after the disposal of the matters by the High Court, any appointments are made by the madrasas concerned, such appointment of teachers shall be deemed to be valid for all purposes. But the Commission shall hereafter be competent to select and nominate teachers to various madrasas in accordance with the provisions of the Commission Act 2008 and the rules framed thereunder. My lord, so this is somewhere they are trying to, my lord, take benefit of this. My lord, Mr. Doras substantially addressed. But so therefore, my lord, essentially, the window which gets created, my lord, is 9 December 2015, my lord has seen, to 14th March 2016. This is the window, my lord. The division bench of the High Court and the stay given by the Honorable Supreme Court.
Yes.
Where, so my lord, this window is the window, my lord, all problems emanate from. Now, my lord, so thereafter, my lord has seen, my lord, the contempt petition being filed, 3-man committee being set up, and my lord, my lord has seen Sri Ashish Giri, my lord, 2nd February 2023. My lord, the parameters were set down in terms, my lord, of the two notifications. My lord has seen that, and my lord, for people who are to be likely to be affected. My lord, Justice Devi Prasad De's committee considered the appointments, my lord, of close to 500 people, my lord, and held each of such appointment to be invalid. All of these appointments, my lord, to be invalid. Now, my lord, then,
Yes.
then, my lord, we come, my lord, to the decision which, my lord, brings us to a quietus to the disputes in Najma. Now, my lord, Najma has been also been placed before my lord, but my lord, I will trouble my lord. My lord will be, I'll take my lord through the most relevant portions in my most humble opinion, my lord, in my most humble submission, my lord. Page 5, paragraph G, my lord has seen 5G, my lord, at page 5, paragraph 5G. Prior to and post the said judgment and order of the division bench, the state government had issued 2 notifications dated 9 February 2015 and 4th March 2016 respectively, while notification 1 laid down recruitment procedure in institutions exempted from recruitment from West Bengal School Service Commission under section 15A. Notification 2 introduced recruitment procedures for the non-government recognized aided madrasas, primary, junior high, higher secondary and senior of 2016. These 2 notifications were intended to regulate selection and appointment of teachers and non-teaching staff. But at notification 1, I have handed over to my lord. I have not yet placed that, my lord. So therefore, my lord, this is the issue with respect to the 2 notifications. My lord will be pleased to take page 7, my lord, internal page 7, my lord. My lord, M. My lord has seen this court's order allowing the appeal on the terms noted above wiped out the declaration of invalidity of the MSC Act. Ultimately, my lord, upheld as seen in my lord Rafiq. N, my lord, closure of the appellate proceedings triggered by the challenge to the MSC Act did not bring about a quietus to the controversy. Rather, it was quickly followed by initiation of petitions alleging contempt of the directions made in Sheikh Mohammad Rafiq. The contempt petitions came to be decided by a 2-judge bench presided over by such and such, vide its judgment and order in Snehashish Giri versus Shubhashish Mitro. Having regard to the claims and counterclaims of the parties, the bench proceeded to pass the following order. Accordingly, this court, exercising its powers under Article 142, hereby constitutes a committee headed by Justice Devi Prasad De, retired Judge, Calcutta High Court. The committee shall also consist of a principal secretary, ranking officer of the IS who had served in the West Bengal cadre and stationed in Kolkata with experience in the higher education department, as well as a retired registrar of one of the state universities in West Bengal, residing in Kolkata. The state government shall nominate the members other than the chairman. The committee is requested to consider the claims of the petitioner, keeping in mind the following. My lord, so this was the test and, my lord, the directive of the Honorable Supreme Court given to the committee, my lord. On this, in this threshold, my lord, the committee checked whether each of these petitioners, my lord, were eligible. My lord, whether the madrasa or its managing committee was recognized by the state government on the date on which the appointment was made. My lord, some of the petitioners here have failed to cross the threshold. Whether such appointments were made of candidates who possessed the requisite prescribed qualifications and fulfill the experience and other eligible conditions stipulated for the post concerned. Whether such an appointment was made by following the recruitment procedure indicated in the Gazette notification dated 11/3/2015 and in Kolkata Gazette notification dated 4/3/2016. So these 2 notifications, whether the appointments were made against vacancies that existed and whether the vacancies conformed to the staffing pattern for the institution or madrasas concerned, whether after the appointments were made, the persons appointed actually worked on their respective posts, and whether the appointments were actually made on the date of the appointment letter or were backdated. So, my lord, these are, my lord, essentially
Yes.
4 conditions plus notification 1 in this case. So, my lord, I'm sorry, my lord, 5 conditions A, B, D, E, and F have to be satisfied plus the conditions in notification 1. So, this is, my lord, the threshold which the petitioners before my lord even today will have to cross, my lord. Why, my lord? I'll demonstrate, because there was a wide publicity given to this. So, my lord,
Snehashish Giri was disposed of,
my lord,
with that direction only.
My lord.
That the committee has been formed and it will decide.
My lord, grateful. So, my lord, what I'm trying to stress before my lord is A, B, D, E, and F plus C, which is either notification 1 or notification 2. In this case, notification 1. So, my lord, these thresholds, my lord, have to be crossed. My lord will be pleased to take internal page 10. Paragraph 7 of Najma, my lord. So, my lord, I'm primarily basing, my lord, on Najma. This, my lord, settles the dispute, my lord, to a great extent.
7, yes.
Paragraph 7. My lord, the paragraph starting with "we once again grant liberty." My lord has that?
Yes. Najma, you are referring to para 7?
My lord.
No, para 7.
Oh, I'm sorry, my lord, I'm sorry.
Para 7 on behalf of the petition starts.
My lord, this is 5 A, B, C, D. My lord, page 7, my lord, will be pleased to take.
Page 7.
Page 7. Very well, my lord.
Page 7 you were reading
under S. I'm sorry. S. My lord. My lord, S. My lord, 5 A, B, C, D, E, F, G. My lord has that.
Yes.
Internal page 10. My lord has that.
9 is there.
Yes. Yes. 9. 9 is S. Finally, all the writ petitions.
Yes.
Next page, my lord. We once again, my lord.
Yes.
My lord. So therefore, in this matter on 19 November 25, there was, my lord, preliminary hearings were conducted. What was observed? We once again grant liberty to the advocates on record appearing on behalf of the petitioners to identify cases of not more than 10 teachers and 5 non-teaching staff. That is why my lord has mentioned 10. But not more than 10 teachers and 5 non-teaching staff who have been grossly wrong to persuade us to hold that the committee was unjustified in spurning their claims. So, my lord, their best cases, 10 teaching, 5 non-teaching, put forward the best cases. That was, my lord, the directive of the Supreme Court. So they did that. While projecting the cases of these 10 teachers and 5 non-teaching staff, we require answers preferably on affidavits to the following questions. Whether on the dates the petitioners were appointed in the concerned madrasas, names may be disclosed as claimed, such madrasas enjoyed valid recognition granted by the West Bengal Board of Madrasa Education, whether the managing committee of the concerned madrasas where the petitioners claim to have been appointed were valid managing committees in the sense that the same were duly constituted in accordance with the management rules and had the imprimatur of the Madrasa Education Board. Subject to the answers to the aforesaid 2 questions being in the affirmative, what is the educational qualification of the petitioner and on which post in which madrasa was he or she appointed? What was the staff pattern of the concerned madrasa in question, both teaching and non-teaching staff, as on date of the selection process was initiated and appointment of the petitioner made either as teacher or non-teaching staff? Whether the permission of the relevant district inspector of schools was required for initiating the selection process. This is important, my lord. In notification 1, my lord, I'll demonstrate. If no, why? If yes, was it sought and obtained by the managing committee prior to initiating the process of selection? My lord will be pleased to mark this. Whether the petitioners applied in response to any advertisement. If yes, where was the advertisement published? What is the nature of competition and the test or examination that the petitioners faced prior to appointment? Whether the managing committees with their own recommendations and the recommendations of the selection committee constituted for the purpose had forwarded all papers together with the panel or merit list to the district inspector for approval. Whether the district inspector had approved such panel or merit list leading to appointment. Whether the service of the petitioner upon appointment was approved by the district inspector. Any other information that the petitioners would wish to disclose relevant for a decision on the writ petitions is permitted to be disclosed. So, my lord, 1 and 2, once they cross thresholds 1 and 2, then, my lord, 3 to 10 had to be answered. So, my lord, this was the test. 15 of their best cases before the Honorable Supreme Court. My lord, paragraph 12 at page 12, my lord, internal page 12. Having heard the parties, the dispute seems to lie in a narrow compass. The committee was set up to filter claims. Parties were put on notice, and those petitioners who presented themselves before the committee were heard. A painstaking exercise was undertaken by the committee, which revealed that not a single claim met the threshold of a valid appointment. No claim was found to be genuine on individual assessment, and the rejection was on merits and not on technicalities. Petitioners who suffered rejection of their claims upon due consideration now seek to re-agitate issues of fact which have been settled by the committee. My lord, this was in effect a last chance given by the Honorable Supreme Court. My lord, ideally it was the committee which was, my lord, the authority and the body which made wide publication. If you have anything to demonstrate, please come before the committee and demonstrate whether you are eligible or not, and whether you cross those thresholds, my lord, as set up, my lord, those 6 pointers, including notification 1 or 2, you have to satisfy. My lord, even after that, they did not come. My lord, then the Supreme Court heard them. And now, my lord, we have these bunch of petitioners coming up before my lord. My lord, now paragraph 13. We are conscious that absent manifest perversity in the findings of the committee, the judicial review court ought to stay at a distance. However, considering that this is the court of last resort and that there has been protracted litigation since 2014, as a very special case, we were a bit indulgent. Accordingly, we proceeded to treat these writ petitions essentially as appeals against the findings of fact recorded by the committee, subject to the rider that not every claim would be considered. Instead of a random choice, which we could have made, we extended due opportunity to the advocates for the aggrieved petitioners to screen and project inter se the glaring instances of gross injustice and to demonstrate infringement of their legal rights for the same to be remedied. 14. Such screening and selection having been made at this stage, we were tasked to consider and examine the claims of only those 13 petitioners named above, and to conclude whether there is any ring of truth in their claims that they were validly appointed by the respective managing committees of various recognized aided madrasas between the dates of rendering of the judgment by the single judge of the High Court in managing committee, the Rahmania High Madrasa judgment, declaring sections 8 and 10 to 12 of the MSC Act ultra vires, Article 30, and pronouncement of the judgment by this court in Mohammad Rafiq, declaring that the MSC Act does not infringe any right of the minorities in the state of West Bengal. If the examination reveals truth, legitimacy, and justification what the petitioners assert, they would most certainly be entitled to have their services approved on the premise that they were appointed in the interim in terms of the provisions contained either in notification 1 or notification 2, and also other consequential benefit flowing from such appointment. Also, a positive finding could open the gates for the others for their claims to be individually examined. However, if not a single claim is found genuine out of the selected few to be considered, closure of the proceedings once and for all would be the obvious consequence. My lord, I'm laying great stress on this, my lord. The Supreme Court has ultimately arrived at a closure of all of these disputes, my lord, a quietus to the disputes, my lord, which were raised.
Yes.
My lord will be pleased to take the next page, 14, internal page 14, paragraph 16, my lord. My lord has seen, this was also placed by my lord, Senior Counsel Mr. Dhar. The same contention was urged by Mr. Roy before the coordinate bench deciding Snehashish Giri. Such contention was negative in the following words. I'll place just a few lines, my lord. In para 64, the court in Mohammad Rafiq declared the nominations by the commission in pursuance of the provisions of the act as valid, and the appointments made after the disposal of matters by the High Court as deemed to be valid for all purposes. However, there is no discussion with respect to whether the court had applied its mind as to how the madrasas had proceeded to appoint teachers as teaching or non-teaching staff. Also, there is no discussion regarding rules or regulations applicable, circulars and guidelines in terms of which aided and unaided recognized institutions could make appointments, having regard to the standard of education required and the requisite experience. Whether a transparent method was followed, whether the madrasa concerned was recognized one or not, whether the committee or body selecting the individual was constituted in accordance with the rules and regulations. The argument of the respondent alleged contemners that there ought to be an exercise of verification therefore appears to be merited and substantial. So therefore, my lord, what we are trying to undertake right now, my lord, is also that same exercise which was upheld by the Honorable Supreme Court, my lord. Exercise of verification is merited and substantial, my lord. What is being attempted to be done now is an exercise of verification, my lord. Their rights have not yet been affected. They've just been asked to demonstrate, my lord. That one page, my lord, I will show. Next paragraph, my lord. In the present case too, this court is of the opinion that the respondents stand that without verification of the petitioner's appointment and whether the procedures prescribed were duly followed in respect of matters such as fulfilling eligibility conditions, essential qualifications and relevant experience, availability of vacancy staff pattern in respect of madrasas where recognition was granted, and if so, for what period, whether the institution was aided and recognized or not, or recognized and non-aided, and if so, for what duration, whether a duly empowered selection body or bodies considered the candidature of the claimant before he or she was appointed, and whether the committee or body selecting the individual or claimant was constituted in accordance with the rules or guidelines is justified. In these circumstances, this court is of the opinion that further proceedings cannot be continued, as no determination can be made unless there is a due verification in regard to the employment of each of the petitioners, my lord. Every individual case has to be tested individually with respect to their eligibility, my lord, conditions being satisfied and met. It is thus apparent that if this court were to pronounce upon the merits of the respondent's position, it would necessarily have to consider the facts of each case and decide whether the stand of the alleged contemners wherever a decision adverse to the petitioners is taken is correct on its merits. That exercise is not admissible in proper exercise of contempt jurisdiction. Above observations would ordinarily have been conclusive and dispositive of the present petitions. However, this court is conscious of the fact that the process of verification undertaken by the state would result and may lead to multifarious, spelling out uncertainty to individuals and members of the staff of madrasas who were appointed after following all norms and procedures. Now, my lord, next paragraph, a few lines. It is therefore clear as day that the observation made in paragraph 64 of Sheikh Muhammad Rafiq, relied on by such and such, was duly considered in Snehashish Giri, and bearing in mind the factors referred to in the extracted passages, further directions were issued regarding constitution of the committee for verification of the claims. On the point as to whether the appointments are valid or not, the directions in Snehashish Giri constitute binding directions which each party to the lease is now bound to follow. Well, this Mr. Dhorak placed. Now, my lord, next page, my lord, will be pleased to take paragraph 19.
Yes.
Since either notification 1 or notification 2 was required to be followed by the managing committees of the recognized and aided madrasas, it would be worthwhile to note the relevant clauses therefrom. So, my lord, 4, 5 and 7, my lord, I will place notification 1 separately because, my lord, here they are guided primarily by notification 1, even by their own case. That I will place, my lord, subsequently. So, therefore, my lord, the Supreme Court is saying either the act, so act cannot apply. So, either notification 1 or notification 2, my lord. At best, that is their case, my lord. My lord will be pleased to take, my lord, at internal page 19, my lord. Paragraph. My lord, this is the first case which the Honorable Supreme Court was looking at, the case of Rajkumar Bagh. This was also alluded to by Mr. Dhar. I'll place just, my lord, the last portion at paragraph 19, subparagraph I, my lord.
Yes.
My lord has that. Notification 1 does not specifically refer to the judgment and order dated 12th March 2014 of the single judge, yet we cannot ignore the fact that the said notification was issued close on the heels of such judgment. The very strict standards of selection for appointment that the MSC Act envisaged, though no longer applicable in the manner as mandated because of judicial intervention by the High Court, did neither vest the government in the school education department with any authority to dilute the standards, nor did it attempt to do so. A strict standard was nevertheless sought to be maintained, with the only change being the identity of the selector. Instead of the commission, it became the managing committee. Therefore, to accept the contention that the provision should be read as directory would result in dilution of standards, which was neither intended nor permissible, since it would have the effect of defeating the object of ensuring merit-based selection. We thus reject Mr. Such and Such's contention that the requirement should be read as directory and not mandatory. Mr. Such and Such's claim of a valid appointment thus has to fail. So, my lord, notification 1 conditions have to be strictly abided by, and my lord, the high standard set have to be respected, my lord, and followed. My lord, will be pleased to take, my lord, next page, my lord, page 21. My lord has that. C, my lord, just before paragraph, my lord, 26. My lord, ABCD at the top. C. However, where this petitioner's claim is found to falter is that the managing committee of such and such madrasa failed to comply with clauses 5 and 7 of notification 1. Neither were an advertisement issued include inviting applications as required, nor was the DSC West Bengal and or the DIOS concerned kept informed of the process. So, my lord, this was with respect to, my lord,
Okay.
my lord, here now, my lord, will be pleased to take, my lord, internal page 28. But here I will not lay great stress because it was primarily notification 2, but the conditions laid in the notification, my lord.
Which clause?
My lord, this was my lord, 32B, but it was primarily notification 2. So, my lord, I am not laying great stress upon this, my lord. But, my lord, nonetheless, my lord, now, my lord, will be pleased to take internal page 32. My lord, this is dealing with that of the last such featured candidate, number 13. My lord, 35D, page 32, my lord.
Yes.
In any event, the appointment letter cautioned this petitioner that his appointment and joining would be subject to the result of the pending case before the High Court or this court. This is clear indication that the appointment was conditional. My lord notes this, my lord, and at the same point of time, my lord will be pleased to take page 154 of this writ petition, my lord, Tariqul Molla. 154, my lord. This is that of much later dated 28 November 2016, issued by the Additional District Inspector of Not 24 Parganas, my lord. Page 154. My lord has seen, my lord, just below the table. These approval of appointment are accorded subject to the final decision of the Honorable Supreme Court in 6661 of 2016, such and such. This Rafiq was followed, my lord, by these two decisions. So all of these appointments are, my lord, conditional. They did not have any indefeasible permanent right to such employment, my lord. It was absolutely conditional. So this is where the Supreme Court, considering the last featured case, also holds, my lord, that the appointment letter is cautioned. My lord will be pleased to take page 33, my lord, of Najma. G.
Yes.
My lord, G. My lord, just carrying on with this, my lord. However, because of his conditional appointment, this petitioner has no legally protected right which can be judicially enforced. With the decision in Rafiq, Supra, the MSC Act was upheld, and notification 1, que the recognized aided madrasas, and notification 2, which held the field in the interim, stood impliedly repealed and ceased to be operative. Since this petitioner's appointment was subject to the result of the pending cases, if any, before the High Court or this court, allowing of civil appeal such and such, rendered such appointment non-est, being contrary to law, my lord. So they had taken the risk, my lord, of this employment. They tried to take advantage, my lord, of a window, which I will say, my lord, in my most humble submission, raises, my lord, a lot of, my lord, confusion, if I may use a mild term, instead of that you using the term suspicion, all of these appointments within the window done in a very hurried manner and in a hurried fashion. And my lord, I will show notification 1 was not even followed in these cases, my lord. They had to either follow notification 1 or notification 2, both of which, my lord, fell down by virtue of MSC Act being held to be intra vires, my lord. They were holding the field 1 and 2. They fell, my lord, with this. My lord, will be pleased to take paragraph 37, same page, my lord, towards the bottom of the page. A wholesome consideration of the materials placed on record completely contradict the claims of the 13 petitioners that they were validly appointed in the madrasas concerned. Spurious claims have been raised by these 13 petitioners, which obviously are devoid of any merit. The appointments in question are a blot on the system. They must therefore be erased and not protected. The above 13 petitioners, it was claimed, they were the worst victims of arbitrary action. The Honorable Supreme Court Justice Atta's bench said that find out your best cases, or rather people who were the worst placed. Find out your best cases. And they came up, their best was not enough, my lord, to qualify. The cases of the other petitioners must, my lord, if this be the high watermark of arbitrariness alleged, the cases of the other petitioners must necessarily be still weaker and undeserving of attention. One can only speculate as to what merit, if any, the cases of the others disclose to justify invocation of the writ jurisdiction of this court for relief. Since none of these 13 petitioners has set up any case for interference, we are not inclined to look into the claim of any of those petitioners. Now, my lord, paragraph, my lord, will be pleased to take the next page, my lord. My lord, or my lord, the same page, my lord, will be pleased to take. My lord, 41, paragraph 41, my lord, just after Chamundi Mopeds was cited. In view of the order dated 14 March 2016, granting stay, the judgment and order of the division bench under appeal, in which the judgment and order dated 12 March 2014 of the single judge had merged, did not get wiped out. However, definitely the same was operative, judgment and order, until 14 March 2016. And as soon as the stay was granted, it became inoperative. The order of stay, read with the subsequent order of 17 May 2018, referred to, thus created a vacuum. Neither the MSC Act nor notification 1 or 2 could operate, which were issued in aftermath of the two judicial decisions. To overcome the stalemate, the managing committee seeking or to have approached this court. Now, Mela, this is important. To overcome the stalemate regarding filling up of vacancies, the managing committees of the madrasas seeking to fill up vacant posts ought to have approached this court to guide them as to which law they should follow. They could not have on their own proceeded with the appointment process, perceiving notification 1 or 2 to be still valid and operative qua the madrasas. As a stream cannot rise above its source, notification 1 and 2, owing its existence to the judgments of the single bench and division bench of the High Court dated 12th March 2014 and 9 December 2015 respectively, could not remain operational once the latter judgment was stayed. Appointments came to be made in a couple of cases post reservation. Now, my lord, skipping these few pages, my lord, few lines. Next paragraph, my lord. Consequently, para 42, my lord, we do hereby reject the claims of all the petitioners. Since the claims stand rejected, there is no question of these petitioners being entitled to any arrears of salary and allowances. Notification or with appointments not having been made either in accordance with notification 1 or notification 2, the state cannot be fastened with any liability to release payment. Orders passed on the writ petitions restraining the respondents from dislodging these petitioners and or directing payment of admissible salary and allowances stand vacated forthwith. So, my lord, this is where Najma,
yes,
my lord, they were harping a lot on, my lord, release of salary. My lord, release of salary does not create any right, my lord, so to say, to employment or does regularize their appointment. My lord, the government of West Bengal, the principal secretary, issued the notification, my lord, of 16 November 2016, specifically providing that release of salary would remain subject to subsequent verification of the legality and eligibility of the engagement and would not create any precedent or prejudice the state's right to examine such appointments. So release of salary, my lord, was subject to, it was purely provisional, and my lord was subject to the dispute, my lord, being finally laid to a rest by the Honorable Supreme Court. Now, my lord, I will place, my lord, notification 1 before, my lord, which they are claiming, my lord, the 2015. So, my lord, just, my lord, to give a brief overview, where these petitioners were, my lord, they have been recalcitrant fence sitters, my lord. And, my lord, they were testing the waters which way they blow, winds which way they blow, and then they will jump into the fray. My lord, they did not go before the committee. They did not test themselves in Najma Khatun. They, at no stage of the proceedings, my lord, they thought that they will get these, my lord, verified, approved for whatever within the window period. Now, my lord, what is being sought to be done, that letter has been placed, my lord, before, my lord, is that you please come and show your documents in compliance with the directions of the Honorable Supreme Court. My lord, with the, if they are able to demonstrate that yes, this process was followed, inevitable consequence will be that they are entitled to the employment or appointment. However, my lord, in case they fail to but not only they will have to show their letters, it also has to be, my lord, on the part of the state. State will also examine and verify whether these other procedures were followed or not. So this, under notification 1, whether these procedures were followed, and, my lord, whether being recalcitrant fence sitters, they can come now and join in the coming to the fray and say that yes, and get, my lord, a declaration from my lord that yes, they have been validly appointed. My lord, so where is the problem in them being, in coming up and showing their documents before this court, before the authority, my lord, and jumping to come up before my lord? My lord, in my most humble submission, my lord, the appointments, to use the phrase, my lord, my lord, are suspicious. They raise, my lord, the dates raised, the Honorable Supreme Court also says, none of these appointments, my lord, till date have been found to be valid. None of them, my lord. They have been tested till the apex court by the committee. There was a fact-finding committee, my lord. Even the fact-finding committee, my lord, assuming for a moment that it comes up in writ jurisdiction, writ court will not examine the facts. What prevented them, precluded, my lord, them from the fact-finding committee also did not find anything valid. So not a single appointment, my lord, till date has been found to be valid, my lord. And now they come and say they want to obtain, my lord, an interim order from my court, from my lord, saying that my lord will have to prima facie hold that very well, my lord, they are not supposed to go and show their documents. That, my lord, in my most humble submission, my lord will be pleased not to hold, my lord, that they should not demonstrate and show their documents, my lord, before. My lord, now notification 1, my lord, the 2015 notification.
Yes.
Whereas in terms of notification number 641, 1974, special rules have been granted to several schools, and whereas a number of schools have obtained religious minority certificate from the National Commission for Minority Education Institutions or from Minority Affairs and Madrasa Education Department, West Bengal, and are eligible to be exempted under Section 15A of the West Bengal School Service Commission Act 1997 from recruitment through the West Bengal School Service Commission established under the said Act. Now, therefore, the Governor has been pleased to order that all school authorities shall strictly observe the following in the matter of recruitment of teaching and non-teaching staff. The school authority shall submit, along with proof of existence of vacancy for the post applied for in respect of assistant teachers and non-teaching staff, along with the following documents, at least 3 months earlier before the date of occurrence of vacancy in respect of an existing post. A non-litigation certificate against the sanctioned vacant post. The recruitment should be justified considering class-wise pupil-teacher ratio, existing staff pattern of the school showing the category, past graduate or honors, PG category with post-sanctioning memo, subject approval from the council for high secondary section or in case of high secondary schools, resolution of the managing committee, proof of the minority status of the school, recognition of the schools from the West Bengal Board of Secondary Education, West Bengal Council of High Secondary Education, cause of occurrence of vacancy. Upon receipt of the prayer, the district inspector of schools will examine the issues and on being satisfied shall accord approval of appointment of assistant teacher and non-teaching staff, including librarian of high schools against vacancy of posts sanctioned by the competent authority. The founder or governing body will be the appointing authority in respect of headmaster, headmistress, assistant headmistress, and the school management committee will be the appointing authority in respect of the other teaching and non-teaching staff. The post of assistant headmaster, assistant headmistress will be filled up against the sanctioned vacant post, provided the student enrollment up to class 10 should not be less than 715 average of last 3 years. The founder governing body shall submit the following documents as follows: non-litigation certificate against the sanctioned vacant post in respect of recruitment of assistant headmaster. Average number of students should be furnished. Resolution of the founder body, governing body, proof of the minority status of the school, recognitions of the schools, cause of occurrence of vacancy. Upon receipt of the prayer, the district inspector of schools will examine the issues and on being satisfied shall accord approval of appointment to the headmaster, headmistress, assistant headmistress of high schools against vacancy of post sanctioned by the competent authority. In the event if the concerned district inspector of schools, additional inspector of schools finds that the information supplied by the school is incomplete or is incorrect, shall forthwith inform the school authority to meet up the deficiencies. For recruitment in a vacant post due to leave deputation, school authority will intimate within 1 month. Number next. The candidates for recruitment of teaching, non-teaching staff, including post of headmaster, headmistress, assistant headmistress, shall fulfill the minimum academic qualifications, professional qualifications, age limit, and citizenship as laid down in Annexure 2, my lord. This is something.
5 and 7 are the respective clauses which has been also dealt with in the.
My lord, that was extracted.
Whether
5 and
that
7
has been followed or not.
My lord, my lord, 5 and 7 is 2 of them. My lord, 5.
Your exercise is pertaining to the direction that was issued in Snehashi's Giri, giving an opportunity or calling upon the parties that since you have not gone before the committee, now you come and
Yes, my lord. That as has rightly followed. So, my lord, now why I was, my lord, also saying, my lord, clause 2 is that, my lord, their minimum academic qualification, professional eligibility can be tested, my lord. It will have to be satisfied, my lord. My lord, now, my lord, all of these, my lord, 3 required qualification, desirable qualifications, not below the level fixed by the government, my lord, in case of non-teaching, appointment shall be made against a clear vacancy in permanent additional post, shall be given after, my lord, 5, my lord, as seen through open advertisement in at least 2 state level dailies. That's there, my lord. Not more than 10%, including post of headmaster, headmistress, may be reserved and to be filled up from members of the minority community, my lord, to which this institution belongs. My lord, a minimum academic qualification, professional qualifications, teaching exercise, age limit, citizenship, as specified, my lord, those have to be satisfied.
Okay. Any other point?
So, my lord, yes. So, my lord, essentially, notification 1 in its entirety, my lord, will have to be satisfied. My lord, 5 and 7 are relevant. Advertisements, dailies, these are there. My lord, the other, whether they have the requisite qualifications, whether that 3-month prior process was undertaken, that have to be, my lord, also, my lord, shown. My lord, so now, my lord has seen. So, my lord, they will have to demonstrate that notification 1, my lord, they have duly satisfied before, my lord. That notification 1 now, my lord, of Tariqul Mullah, my lord will be pleased to take, my lord, the impugned letter of 166.
Yes.
My lord, next, my lord, in compliance with the verdict dated such and such passed by the Honorable Supreme Court, which is the Najma, my lord, 566. My lord, in some non-government aided madrasas, this office requires to verify the validity and legality of the recruitment process followed by the issuance of appointments by the concerned managing committees. In light of the aforesaid judgment, guidelines laid down in order number such and such, dated 2015, my lord, this is the notification 1 and notification 2. In this regard, this is to request you to please attend this office on 6 such and such with all relevant testimonials, papers, documents concerning the recruitment process and the eligibility criteria of the teaching, non-teaching staff of your concerned madrasa, in whose favor provisional approval for appointment or release of salary was granted subject to the verdict of the Honorable Supreme Court in relevant court cases. So, my lord, it is to whom does this letter go? To the concerned madrasas. Madrasas will have to demonstrate that they were, my lord, managing committee was proper. It was legal. It goes to the madrasas. The madrasas will have to demonstrate and show rather, my lord, what is the process that they have followed. Notification 1, my lord, which in fact the petitioner's own statement, my lord, applies. Even the notification 1 lays down these guidelines. The madrasas will have to show and demonstrate whether, my lord, not only 5 and 7, all of these, it may be found that some ineligible teacher was appointed. It may be the case that someone's nationality was not checked. Someone could have been a Bangladeshi national teaching in a school in India. It could also have been the case whether they've checked that or not, my lord. And these are, my lord, this is border districts. In many cases, my lord, these are also involving border districts. So, my lord, all of these conditions have to be satisfied. My lord, in whose favor provisional approval for appointment or release of salary was granted subject to the verdict. So, my lord, their provisional appointment was granted subject to Honorable Supreme Court's directions. Appointment, my lord, salary was disbursed, my lord, subject to, my lord, the decision of the Honorable Court. My lord, right now, my lord, these madrasas, my lord, even assuming, my lord, to some extent that teachers would have some right, madrasas here, my lord, have no right before my lord. They cannot come and show, they cannot come and say that no, we will not show the papers. Assuming, my lord, for some reason it was given to teachers, teachers could also have, my lord, a modicum of right to come before my lord. Here it is the case of where is the, my lord, the locus of the madrasas also, my lord.
So madrasas have not filed.
So my lord, this notice, my lord.
No, the teachers are before.
No, my lord, I understand, my lord. This notice also goes to the madrasas. My lord, this notice goes to the president secretary of the madrasa. And my lord, this also goes to the superintendent Boshirat Amelia Senior Madrasa.
That's all.
Copy was forwarded, my lord, to these persons.
Okay.
So notice is issued to the madrasa, to these people, and my lord, someone else comes, my lord.
I think he has covered the points, so that's all.
I take your lordship directly first to Snehashish Gill. That is the judgment rendered by the Honorable Supreme Court, reported in 2023-18 SCC 529. I believe, madam, this judgment, which is a judgment delivered by the Supreme Court in its contempt jurisdiction, forms
You are appearing in 10.
2023-18 SCC item 14. I'm sorry, madam, item 14.
Okay. 10, 7.
But let me take the best case, which has been of the state, which has been placed before lordship. Kindly take paragraph 8 of this Snehashish Giri. This is the best case they have got, but then I will deal with it.
Reply, what you do is all the replies be made by you and Mr. Sannal as well as Mr. Bhattacharya tomorrow or on Monday.
Tomorrow, my lord. Tomorrow, Monday. Monday, Monday.
As you choose.
Monday. We do it on Monday, my lord.
Continue. Tomorrow you can also make.
My lord, tomorrow. Better on Monday, my lord. Subject to, obviously, my lord, we are to act in accordance with your lordship's desire, my lord. Whatever, my lord, if your lordship is of the view.
Item number 11, who appeared for the petitioner? Mr. Sannal. And in 12,
11, 12 and 13. I'm in 14.
Okay.
So on Monday, my lord, that in the first half.
I was thinking, since Lordship has actually spent so much of time,
tomorrow we can
continue
finish
to
it
do
off.
better if it is done tomorrow.
Tomorrow, my lord,
Not otherwise.
tomorrow there is a difficulty because, my lord, I have a fixed matter in the first half. That's the whole.
Because this was a
has been hearing these matters.
otherwise taking
Somehow the state is very keen to get these matters heard. Unlike the matters which were being heard day before yesterday.
No, I thought
Well, we can do it in the
tomorrow.
tomorrow না কালকে
Take your replies tomorrow.
কালকে আমার একটু অসুবিধা আছে কালকে
Mr. Mojumdar, in the first half at 11, as we have started today, at 11 o'clock, you make how long you will take to make replies?
I have taken I made submission. I made submissions for 20 minutes. The submissions which have been advanced on behalf of the added party and on behalf of the state, it has it is for more than how many hours? 3 hours, I think, right? Kindly give us 30 minutes each.
Actually, the difficulty is, we are not pitted against the state. We are against the commission. The commission has no role, but the commission is going to make all submissions, in order to interpolate it, in a state high, on a higher pedestal.
We will
The difficulty is that they have made a submission, I am told. I am very sorry, they have made a submission.
You were representing the parties as well as you are assisting the court.
Yes.
Today, the commission is
with
pitted
leave of my learned senior,
on the commission. If he comes in aid and tries to assist the court, where is the difficulty?
I was very surprised, why was the commission not assisting the Honorable Supreme Court when Najma was delivered? State was there, Mr. Loknath Chatterjee's client was there, Mr. Suleiman's client was there. The commission was not there. Maybe it was in pen and paper there. One aspect of the matter, I am told.
Tomorrow.
One statement I want to make. A submission has been made by my learned, esteemed senior friend, my elder brother, that, persons who did not get salary and who got salary were before the Supreme Court. If he can produce one single scrap of paper, I go out of court. I have the records of the Honorable Supreme Court. Hey, Abu, acha to? No one. Amar kache ache.
May I just indicate, my lord, your lordship will be taking it up tomorrow. If it is possible, second half, my lord, subject to your lordship. 2 p.m.
12.
Tomorrow, 12 o'clock.
12.
Make it short. Then he has taken 3 hours, he will get 6 hours.
I will not take by the clock, beyond half an hour, max 2 minutes.
Half an hour for me. Because, my lord, they have made submissions. It is there is no problem if a party approaches this honorable court, takes out an application or whatever, represents before your lordship that they are necessary party to the proceedings. But, my lord, it is to aid and assist your lordship.
It has engaged.
But if the stand taken by the party is otherwise, then obviously we have to step in.
12. Tomorrow.
yes 12
Yes,
11 ही था.
Acha, 11.
11
Finish it. Chalo.
যাই না কি
But Mr.
আমি কালকে আমি
আমিও জানি না কি হবে.
লড়াই 11 o'clock তোমার ফ্রাইডে স্যাটারডে বলে কিছু নেই, যেটা আমার একটা এক্সক্লুসিভ ব্যাপার আছে। আমার ফ্রাইডে কি
Heard Mr. Vishnu Bhattacharya, and its advocate appearing for the petitioner. Mr. So, Mojumdar in item number 14. একই হবে উইথ করবেন আলাদা
সোমবার করবো না, এরকমগুলো সোমবার করবো
বিশ্বকালকে শেষ করে
মামলা আবার 4:30
সিনিয়র অ্যাডভোকেট কান্ট্রি ফিক্স টুমরো 11
গেলে ওখানেই যাবে আমার কাছে
পুরো 11 AM কালকে 11 AM লিখে
Tomorrow.
I don't have time. I can't give you time. I can't give you time. I'm sorry.
Grateful.
Yes.
তোমরা মানে কি যে করছো
Sorry.
What is he?
He's scolding. And he has appeared with me, and I have appeared with all of them. Now he's scolding me.
Rightly done.
In fact, I was thinking sometimes we say best. It's a song also when we say nothing at all. So when he said this, I was silent. And Lordship was only nodding. But thereafter, Lordship spoke it what I was also thinking.
I'm grateful to you.
Thank you.
And silence is not always eloquent.
Your Lordships are getting enough number of brothers.
Oh,
That matter is.
thank you.
What was it? 15 matter, my lord, will be taken.
Which one?
283 and 284.
Yeah. Okay. On Thursdays, Mr. Ganguly, we'll take it up on Thursdays. On Thursdays, the matters will appear under hearing, all hearing matters.
There is a kindly fix a time.
Time, there are only 3-4 matters in the hearing. We'll take it up on Thursday. Okay, time dawa achi to.
Yes, my lord, it was
On the next day, same time.
deeply appreciated.